to mention the monthly list matter 1787. This is extremely urgent. My
Today
lord.
is not the date for mentioning.
Yes, I know that. That's why with leave,
Yes,
my
what
lord.
is the urgency?
Urgency, my lord. This fixation of higher pay scale it is covered by the special court judgment, my lord, and the petitioner is a special child, and his husband is not taking any care. This is extremely urgent, my lord. Kindly fix it.
Higher scale of pay.
Higher scale.
It's not an urgent matter. Maybe he is a specially able person. She is specially able person. It's not an urgent matter. She is getting salary regularly.
Yes. Well, kindly, as per your convenience, any day, my
no fixation of date is possible in this matter. Higher scale of pay is not an urgent matter, Mr. Mishra. He is getting salary regularly. Only his pay might be refixed. So there are several matters in my list.
And it is covered by.
If I accommodate your matter, at least 200 matters have to be accommodated.
That is true, my lord.
So yes, and try to appreciate the predicament of this court. Yes.
Great.
My lord, I'm representing two teachers. Their salaries, their arrears.
Why you are mentioning today? So Monday is the date for mentioning. Please mention on Monday.
Kindly give me a few seconds, my lord. Their salary.
Please mention on Monday.
My lord, I am also praying for updatation in Lordship direct session.
Today is not the date.
Lordship, I shall come back on Monday.
Everybody knows. More than 45 minutes I have accommodated for mentioning on last Monday.
Item number 1.
আমার কবিতাই দিতা আমি পড়ে দেব নাও তুমি আমারটা পড়ে নাও তুমি আমারটা দুজনে দেখে নিয়ে
My lord, as per your lordship direction.
Yes, ma'am.
এই
Direction.
Yes, report.
দিলাম না আপনাকে?
Yes, report.
Yes, my lord.
Yes.
Third page, my lord. My lord, that is the ADM LR, my lord, is the authority, my lord. Previously, my lord, one time that the ADM LR, my lord, was demarcated that plot. At that time, he was in his presence, my lord, according to 152 page 152, my lord. Now, my lord, ADM LR is the authority, my lord. If your lordship was pleased to direct ADM LR to demarcate the land within certain times, my lord, with the help of the BLRO and the special land acquisition officer, then, my lord,
it is possible.
Yes, my lord. That is possible, my lord.
Where you have stated in your report that ADM LR is, have you stated it?
Yes, my lord. Third page.
Third page.
Yes, my lord. Here, my lord, ADM.
Just a minute.
Yes, my lord. direct.
Now, your special land acquisition officer South
He's-
Dakota says that the responsibility rests upon
BLRO, but my lord,
Kosba.
as the my lord, ADM is the authority of map and other things, my lord, and he is the authority, my lord, to
ADM
ADM LR.
LR.
Yes, my lord. He is the record. All the records is lying with the and with the aid with the permission of that, my lord. All the things was done by the BLR. Only for
So
that
now
is
you are saying that BL and BLRO Kosba is not the appropriate authority.
ADM LR is the appropriate authority.
Not
As,
BLRO Kosba.
yes, my lord.
But
BLR.
your land acquisition,
Yes,
special
my
land
lord.
acquisition collector is saying that it is BLRO
My lord,
Kosba.
that is BLRO is the my lord demarcate the land as per order of the that point was not in the as because yesterday my lord he has come to affirm the affidavit only for that reason, my lord. I can't ask him to correct and according to the provision, my lord, ADM LR is the authority.
So how much time will be required for demarcation?
Within 2 months, as because my lord, there is
months.
yes, my lord, as because there is a previously, my lord, if your lordship would come page 152. Previously, my lord,
Demarcate and come back
yes, my lord.
because that is the only player in the
Yes, my lord.
in terms of the order dated 15 January 2025.
And for the private response.
Yes, I know you have nothing to say in
Oh,
this
but
matter.
let a copy be made over. They has been kind enough to show me his copy.
In terms of the order dated 15 January 2025,
আমাকে পরে পাঠিয়ে দিও।
a report
হ্যাঁ, yes, আমাকে
in the form of affidavit
তো ও আছে। হ্যাঁ, ঠিক আছে। তুমি আমাকে একটা পাঠিয়ে দিও তাহলে।
has been affirmed by Special Land Acquisition Officer South 24 Parganas on 18th February 2025 is filed today and same is taken on record. Next paragraph on perusal of a document dated 17th February 2025 issued by the Special Land Acquisition Officer South 24 Parganas, which is in the form of status report, reveals that the original land in question was measuring 60 kota 6 chatak 28 square feet under RS plot number 414 of Mouza Madurdaha. Stop. Said plot was requisitioned under the West Bengal Fisheries within bracket Requisition and Acquisition close bracket Act 1965. Vide LA capital, LA case number Roman 20/45 of 1966-67. Stop. Subsequently, part of said plot number 414 was released from the requisition vide order dated 19th February 2015 of Land and Land Reforms Department within bracket LA branch, close bracket, Government of West Bengal. Stop. Subsequently, entitlement of possession as per deed of the petitioners was determined by LA Collector South 24 Parganas in 2015. Stop. according to Special Land Acquisition Officer, South 24 Parganas, BL and Ilaro Kosba, within bracket now BL and Ilaro Kolkata, close bracket, is the authority to demarcate the aforesaid plot of land based on application made by the petitioners. Stop. Next paragraph. However, Mr. De, learned additional government pleader, on instruction submits that additional district magistrate LR
Yes, my lord.
of South 24 Parganas,
Yes, my lord.
South 24 Parganas may be directed to take steps for demarcation of plot of land in question instead of BL and LRO, comma, Kolkata. Next paragraph. Having considered the report furnished or filed today and taking note of the status report dated 17th February 2025 of the Special Land Acquisition Officer, South 24 Parganas, and it is submitted on behalf of the state respondents today that direction needs to be given upon additional district magistrate LR for demarcation, comma, said additional district magistrate LR is directed to complete the demarcation process of
My
the
lord, with the
land in question
with the help of the BLRO
with the help of concerned
BLRO,
BL and
yeah.
LRO
and the special land acquisition officer.
and
Land acquisition officer.
the special land acquisition officer within a period of 6 weeks from the day from date. Stop. Petitioners are also directed to cooperate with the authorities in to complete the demarcation. Stop. Next paragraph. Let a report be furnished by additional district magistrate LR on the next date, disclosing the demarcation of the land in question.
Yes.
Stop. Whether ADM is party.
No, my lord, he is not a party.
ADM is not a party.
Next paragraph. Learned advocate for the petitioners is granted leave to amend the cause title of the writ petition and implead additional district magistrate LR South 24 Parganas as additional respondent in course of this day.
Yes, my lord.
Stop. Service of notice upon the additional respondent stands dispensed with, since state respondents are represented represented by learned advocates. Next paragraph. List the matter under the same heading on April 16th, 2024.
Yes, sir.
Grandmother, that the exercise of demarcation will take place in presence of all parties.
Yes, my lord.
Next matter.
Grateful, Lord.
Amendment করে দেবেন। Item number 2.
I'm being led by the Lord. On behalf of the petitioner, and these two matters were not, as I had indicated, my lord, on that occasion. The state has come up with two proposed dates, my lord, for the date of post, my lord. Copy, sir.
Election of which election? So of
This is-
constitution of which board?
This is the board of director election in respect of, my lord, Deshopran Samobai Krishi Unnayon Samiti Limited.
Where you have stated.
But that is rare also, my lord. Player A, my lord. Player B, my lord. Page 19.
Deshopran SKUS.
Right.
When initially the date of election is
So the
fixed.
Board of Directors, my lord, that expired, the tenure expired on 8th of December 2021. The election was scheduled on the 27th of
8 December 2021.
2021. Election was scheduled on the 27th of December 2024.
Just a minute.
Right. 27th of December 2024, the election was scheduled.
Yes.
Suddenly, my lord, on 26th of December 2024, the election was postponed by the Cooperative Election Commission, citing that
Law and order situation
police is not in a position
to provide
to provide security.
security. Now, when it can be conducted?
Now, my lord, this particular society's election, my lord, can be conducted, my lord, on 2nd
March.
2nd of March. Because decision was taken 2-3 weeks back, but due to, my lord, some problem, this or there was
indicated.
since the matter is pending, this was not done. So, Lordship, be kind enough to allow us to conduct election on that date, and police may be directed accordingly to take all necessary measures so that peaceful election may be conducted. That's entirely because police will not compelled us to stop it. That's the letter, my lord, at page 46.
The SP of the district is already by lord a party respondent, respondent number 9, and the
Page
inspector
46, they intimated that stop it.
Matter is heard in view of urgency as explained before this court upon placing it on board today. Stop. Mr. Bilodol Bhattacharya, learned senior advocate representing petitioner, submits that the issue involved in the writ petition relates to holding election for reconstitution of board of directors in Deshpran Samobai Krishi Unnayan Samiti Limited. Which district?
This is Purbo Mendipur.
Purbo Midnapur. Stop. It is further submitted that the term of the board expired on 8 December 2021 and the election date was scheduled on 27 December 2024. Stop. However, concerned authority of Cooperative Election Commission did not permit Samobai Krishi Unnayan Samiti Limited to hold election on 27 December 2024 since necessary security arrangement could not be made by the concerned police authorities.
And they wrote a letter also to that effect at page 46.
Next paragraph. Today, on instruction, Mr. Nayak, learned advocate representing
Cooperative Election Commission.
Cooperative Election Commission, submits that whether it is the date is fixed by the Election Commission or
Election Commission.
submits that the date of election has been fixed by the Cooperative Election Commission on 2nd March 2025.
Subject to lordship. Subject to.
Wait.
Subject to lordship.
I have heard you. 2nd March 2025. Stop. It is submitted on behalf of the petitioner that that petitioner Samobai Krishi Unnayan Samiti Limited is willing to hold the election with the nod of Cooperative Election Commission as early as possible.
I am not the cooperative, I am not the SKUS.
Kindly,
I am one of the members and I have filed my nomination.
kindly excuse me, lord. My lord, society cannot.
You are the one of the members of the society.
I am one of the members, my lord. I have also filed my nomination, my lord, to contest the election.
Petitioner, who is one of the member of Deshpran Samobai Krishi Unnayan Samiti Limited, who has filed a nomination to contest the election, that election needs to be conducted at an early date. Stop. Next paragraph. Having considered the respective submissions made on behalf of the parties, writ petition stands disposed of, directing the
Cooperative Election Commission.
Cooperative Election Commission, West Bengal, to hold election of Deshpan Samobai Krishi Unnayan Samiti Limited on 2nd March 2025, and police authorities of and the superintendent of police Purbo Medinipur is directed to extend all sorts of cooperation for holding free and fair election on the scheduled date. Stop. Urgent Xerox certificate copy.
Next matter is also similar, my lord.
One after another, just a minute.
But the affidavit of service, my lord, may be kept on.
একটু বসো, এটা করে নিই, তারপর তোমার কথা বলছি।
Also filing the affidavit of service.
হ্যাঁ, yes.
Affidavit of service.
ওপরে দিয়ে দাও, affidavit of service filed on behalf of the petitioner is taken on record.
Item number 3.
But this is also similar, the dates will be different.
Just a minute. Yes, what
Filing the affidavit of service.
yes, dates
But the
when
vote- term of the
term
vote
expired,
expired on the 12th of November 2022.
just a minute. 12 November 22.
2022.
Yes,
The election was scheduled on the 29th of December 2024.
29 December
By
2024.
2024.
Schedule correction.
Yes,
Suddenly, my lord, on the 28th of December 2024, this is just a day before my lord,
election could not be held.
election was again postponed, my lord, citing my lord, people in Nandi.
And when you have decided to hold the election?
On Milord on 9th of Lordship March. After a week on the Sunday. Normally Sunday we choose.
Is it necessary under the rules to hold election on Sunday? No.
No, because the space, school and all these are not
9th March 2025.
Lordship.
নেমটা শুধু পড়ে দেবে নরসিংহপুর আসাদতলা সমবায় কৃষি উন্নয়ন সমিতি লিমিটেড, আর টার্ম এক্সপায়ার্ড অন 12 November 2022, scheduled initially on 29 December 2024, date of election 9th March 2025.
Here, my lord, on the petition.
Whether the superintendent of police is respondent number 9?
Yes, sir. This is the respondent number. I'll tell you, lordship.
Yes, 9.
9.
Yes, Mr. Sureka,
Nine.
do you have any objection? Election is held. You are representing register. Enter your appearance. Affidavit of service উপরে করে
In
দেবে।
fact, in terms of section 96 of the Cooperative Societies Act, it is exclusively to be done by.
Within the domain of the commission, cooperative election commission.
Grateful, extremely grateful.
Grateful, Lordship.
Thank you, lordship.
Item number 4. For the state, my lord, in this matter.
Now for the petitioner in this.
আচ্ছা, অঞ্জনকে ডাকো। Just a minute, Mr. Bhattacharya, please.
It is the affidavit of service.
Yes. Who is for the petitioner? You are for the state.
Lordship's order on 22nd of January
Oh,
2020.
just a minute, let me go through my own order. Who is appearing for the school authority?
My lord, will kindly come to straightway or the order of the board. With regard
Now, that is, the claim is regarding difference of pay on adjusting subsistence allowance.
already paid.
So to that extent, since the suspension order has been withdrawn, you have no, petitioner is entitled to receive the same.
But I shall place only one rule before lordship, then whatever your lordship decide.
Yes.
Rule
What
6,
is that?
Rule 6 of my lord, this is 2018 rules. Or kindly excuse me, there is some highlight. Because my lord, your lordship knows after 2018 this deem suspension concept gone. Prior to that, there was there. Now kindly come to rule 6.
Yes, suspension, yes.
Yes, may I read it from my lord? The board may, for the following reasons, issue order of for a suspension against the teacher and non-teaching staff. A. If the teacher and non-teaching staff is under detention in lawful custody for more than 48 hours.
That is the case here.
That is the case, our.
Yes.
So, my lord, even for placing him under suspension, order is required. Now, here the case, he was detention for 12 days or 10 days. Once he was released from there, erstwhile managing committee allowed the petitioner to resume duty and perform. At a later stage, board's order came with a retrospective effect from the date of detention. He was placed under suspension. The subsequent stage, my lord, that has been withdrawn
By the board.
By the board from the date of release, with effect from the date of release. Now, if your lordships kindly turns to clause 3.
So entire suspension order issued by the board relates to retrospective.
Yes.
Effect.
Now, kindly come to clause 3. If the disciplinary proceeding is not initiated or contemplated within 90 days from the date of receipt of investigation report of, or if the teaching or non-teaching employee has been released on bail, the concerned teaching or non-teaching employee may be allowed to resume his duties subject to the condition that such joining of the teacher or non-teaching staff will not hamper the normal running of the institution. That has been allowed. Now, provided that during suspension period, no annual increment, career advancement scheme benefit, revision of pay benefit, any other benefit declared by the government, final pension, gratuity, etc., shall be allowed other than subsistence allowance.
Yes.
Now, why this is, my lord?
Now, what is your contention?
My contention is this, but he was entitled to get subsistence allowance that he already received. Now, this is not in connection with disciplinary proceedings. It is in connection with, my lord, detention. The criminal case is pending till date. Now, the law says, if anyhow at the latter stage he is, my lord, convicted, there is no other provision.
His job.
There is no other provision, he shall be. Now, my lord, taking into that account, this proviso is there. He is not entitled to get any other benefit.
Including difference of pay?
Yes, my lord.
Why?
The proviso is that.
Provided that during suspension period, no annual increment period. But when the suspension is withdrawn?
Well, suspension he allowed to come kindly clause 3, it talks about his resumption of duty. Then this proviso has been inserted, taking care of the situation. Because he has not been given clean sheet. Had it been a case of disciplinary proceedings, he could have entitled.
Suppose in a case,
Yes, my lord.
It's not a case of criminal proceedings. A disciplinary proceeding is initiated.
Then he is entitled.
Now a suspension was claimed. Then suspension was withdrawn. Teacher is permitted to resume duty. Period, say for instance, period of suspension is 6 months. After that, petitioner is or the teacher is allowed to resume duty. Now, after resumption of duty, during the period of during the continuation of disciplinary proceedings, petitioner is not entitled to get the difference of pay.
Yes.
Because suspension ultimately in disciplinary proceedings, punishment is imposed. In that event, suspension order merges with the order punishment order.
Yes.
In the event petitioner is exonerated,
Will
in
get
that
all-
event suspension order goes, petitioner gets.
Now-
Petitioner gets all benefits. Suspension order also merges
Yes.
with the order of exoneration.
Yes. Now,
But
apropos,
here it is the case where
once
the
he is convicted,
criminal proceeding is pending.
once he is convicted,
Once I am
Now,
convicted,
I
I will be punished according to the criminal law.
No,
According to the criminal law, I will be punished.
absolutely correct.
Disciplinary proceeding or I have no, so far as my criminal offense is concerned, it has been held by the board that this has no connection with the absolutely private family dispute. It has no connection with the school affair. Therefore, school had invoked the provision of custody for 48 hours. School has no independent allegation against me. Therefore, if any offense is committed under the general penal law, I will be dealt with by that penal law at the time when I will be convicted in there.
Right.
If I am convicted.
Right.
Therefore, after order of the board, setting aside the order of suspension, how can the school authority say?
But suspension order is not declared to be bad. Suspension order is merely withdrawn, Mr. Bhattacharya, so that you can resume your duty.
As because not
Sub-
connected with service.
please, subject to final outcome of the criminal proceedings. Think about otherwise.
Ultimately, if I am convicted, my suspension will or my service will go.
Yes, and
I-
suspension will be confirmed. Suspension for a limited period will be confirmed.
Suspension was for criminal
If
custody.
suspension was revoked,
I have no grievance.
If-
If there are no suspension.
you would have received entire benefit during this period.
Why this suspension? My custody is the reason for my suspension. Why this suspension? I have no in misconduct against the school
But
authority.
suspension order ultimately depends upon the outcome of the criminal
That
proceedings.
is why the board has said.
Disciplinary proceedings.
The board
Now,
has
in both the proceedings, if
no
ultimately
disciplinary proceeding. Do not
if both the proceedings ultimately petitioner is convicted or petitioner is found guilty, in that event suspension order becomes final.
or that is something, my lord, which is not yet before your lordship.
So
That-
therefore today, Mr.
My-
Bhattacharya, unless until you are exonerated, you are not entitled to get the difference of pay.
So far as the period of suspension is not against me today, the board has said that you are entitled to the area salary, area benefits. Board has said so. That order is not a subject matter of challenge before your lordship. Kindly come to the concluding part of the board's order. In view of page 18,
Just a minute, yes.
the finding, the bail order submitted at the time of hearing, the matter Ganapati is disposed of by withdrawing the order of suspension of the petitioner with retrospective effect from 12 to 2023. The suspension absolutely goes. By directing the school
From
authority,
which date petitioner was suspended?
12 to 2023,
12 to-
that is custody date.
but how could that be, my
From
lord?
12 to 2023 by directing the school authority to
By
submit-
directing to submit to his
So
office
this is the
resolution.
date
Of
of
his arrest.
effect of your suspension.
No, that
Arrest.
Arrest. So you were arrested on 12 February 2023.
That
And
day
when
arrest.
released on bail?
I was released on bail, my lord.
24th, if I'm not wrong.
Yes.
Yes, 24th February bail.
24th February bail.
can
And joined
therefore,
on
of the same year.
joined on 25th February.
25th February. I
So,
find.
so with retrospective effect from, so by withdrawing the order of suspension of the petitioner Ganapati Pore with retrospective effect from 12 February 2023.
Yes.
By directing the school authority, yes, place it, Mr. Bhattacharya.
By directing the school authority to submit to this office a resolution of managing committee regarding the allowing the petitioner to resume his duty along with all his service benefits with effect from 25th to 5th
With effect from 25th February 2023.
2023. So with effect from 23, that is exactly what
And from 26th April 2024.
presently with retrospective effect. twice the use.
Why 26th April 2024 again?
Initially, my
present-
lord,
and from 26th April 24 presently with retrospective effect. So board has not done any mistake, Mr. Bhattacharya. Board has said that with effect from 25th February you are entitled to.
yes, with effect from 25th, along with the service.
So therefore this period only from
Yes.
12th February 2023 to 25th February 2023.
Yes, that period only I am claiming for. I am not paying anything more.
From 12th February to 25th February, these 12 days.
Yes, but not only 12 days.
But-
My join.
That is when he was under custody.
No. My joining was there.
Period is from May 2024 to 10th September 2024 you are praying.
Yes. That
Why
that
take-
is my joining. 25th February 2023 till 11th of September 2024.
No, 12th February you were taken into custody.
Yes.
25th.
That time I continued to serve. Therefore, I
that
got
I
the
know.
salary.
It has got a retrospective effect. So far, board's order is
Yes,
confirmed.
yes.
12th February you were taken into custody.
My lord.
Released on
Obtained
24th
bail
February.
on 24th February.
Yes.
20 after that you joined. You resumed duty on 25th February.
No suspension.
So
was there.
why this period you are claiming this amount from May 2024 till 10 December?
I am bringing after adjustment of the suspension allowance, my lord. I am entitled to from 25th February till 11th of September 24. My prior salary was stopped from 25th February 23 till 11th of September 24.
Entire salary.
With, minus the amount.
But it,
Minus
Well,
the
may I
amount.
give the
no,
dates?
but it should be.
May I give the
you-
dates?
I can understand. I understand your point that for a period from 12th February 2023 to 24th February 2023,
When he was in custody.
Yes.
he is custody and suspended.
Yes, suspended.
Suspended.
Yes.
But on
No,
25th February
at that
2023, whether petitioner was permitted to resume duty or not.
Yes.
Yes.
So he is entitled to get the full
He
benefit. from
he got
25th
it. He got it. But I am giving the dates more kindly. But 12,
Only this period of
my lord,
12 days he is not entitled.
but I am giving. 12th of February, he was arrested in 2023, released on 24th of February 2023.
Yes.
He resumed duty on 25th of February 2023. He continued, my lord, till 19th of April 2024. And he got all his salary.
Yes. The
He got all his salary.
Minus that.
Now,
Not,
adjust that.
without adjusting subsistence allowance.
yes,
Entire salary he got.
entire salary he got. Now,
There was no suspension. There
Now-
was no order of suspension that time.
No, there was an order of suspension.
No, my lord.
What is that?
Suspension
that's the
order
problem.
by the board later on.
Yes, but later on. But it
Retrospective.
retrospective effect.
Yes.
And that will remain valid for a period from 12th February 2023 to 24th February.
Obliged to lordship. Exactly so. I am
My-
not disputing
my,
that.
my submission before lordship. Now, this suspension order that was, my lord, withdrawn on 11th of September 2024.
Yes.
11th of September, I joined.
11th of September 2024, the suspension order that has been withdrawn. Now, my lord, suspension order withdrawn, he is entitled to get all salary from this date of resumption.
No.
During the period he worked,
No,
we have already paid.
say, consider the order of the board.
Yes, my lord.
It says that with retrospective effect from 12th February, withdrawing the order of suspension of the petitioners Ganapati Pore,
My lord,
with retrospective effect from 12th February 2023, by directing the school authority to submit to this office resolution of the managing committee regarding allowing the petitioner Ganapati Pore to resume duty, along with all his service benefits, with effect from 25th February 2023.
and from 26th April 2024.
With effect from 25th February 2023 and from 26th April
The
2023.
two dates are being used.
Period of suspension is only for the period of custody.
Yes.
Now, but he was initially,
But he did not work during this period.
yes, yes.
I worked.
Now, my lord, if we,
No, you joined on 25th
Well, this
February
is-
2023.
Yes.
You joined.
Yes, my lord.
he joined, he continued, my lord, till 25th of April 2024. 19th April 2024, he continued. Now, from 20,
He continued up to 25th April 2024.
my lord, he continued up to, my lord, 20th of April 2024.
20th April 2024.
Yes.
From 25th February 2023.
23.
This
He-
is the period. Then thereafter what happened?
Now, thereafter, my lord, that order of suspension was served. But kindly look this.
Yes, if thereafter order of suspension was served, at that point of time, the relevant period was over.
Yes.
He worked, he got the salary. Now, the, my lord, suspension came. Suspension came with retrospective effect from the date of arrest.
Now subsequently, in the month of September,
So therefore, the picture which is coming is this, that from 12th February 2023 to 24th February 2023, petitioner could not discharge duty. He was taken into custody.
yes,
He obtained bail on 24th February 2023. Resumed duty due to
25th.
laches on the part of the school authority to
No.
bring it to the notice of the
We intimated to the board.
very well. Then,
Mhm.
then resumed duty on 25th February 2023.
Yes,
He worked till 20th April. He
2024.
worked from 25th February 2023 till 20th April
2024 and got all salary.
and received entire
Entire
salary.
salary.
Entire salary.
Yes, madam.
Thereafter, suspension order was issued
Yes,
on which date?
but kindly allow me or I shall. But they didn't annex that document to your lordship.
The
Your lordship.
suspension order is annexed.
No, I couldn't find.
And the 19th of April 2024. With
Where is the
effect from-
suspension order?
Yes, 19th with effect from 12th of February 2023.
Where is the suspension order?
That I couldn't find in this
Even I
petition.
don't want.
But in the earlier did
Show
petition,
me the suspension order.
if your lordships allow me, I can show it.
That is really, yes, show me.
Okay, tap দাও, tap দাও। ছোট tap দাও। ছোট tap দাও, দাও।
Annexed ছিল তো suspension.
Entire period was considered as suspension by an order with retrospective effect.
Yes.
Which was passed after 20th April 2024.
Page 38.
Show me the suspension order. Why suspension order has not been annexed with the writ petition?
Page out. It's this one.
What are the charges? Under which section?
Family
Under which section?
section will not be, I was trying to find out. The board has said the family feud.
What are the sections?
In the FIR.
But sections are 448, 323, 325, 307. That's the attempt to murder. Yes, 354B,
Very well.
506, 509 of IPC. নাইনটিন্থ এপ্রিল এটা আমাদের কমিউনিকেট করেছে।
So suspension was with effect from 12th February 2023.
Yes, the day of
Then
arrest.
This revocation order is dated 10th September 2024, whereby
Yes.
it was directed that with retrospective effect from 12th February 2023 by directing the school authority to submit to this office a resolution of the managing committee regarding allowing the petitioner Ganapati Pore to resume duty along with his service benefits with effect from 25th February 2023. So the period of suspension is for a
Now, one
period of
thing,
12 days.
one thing, my lord.
You don't pay
The-
the rest of the amount for a period of 12 days, but other benefit he is entitled to receive.
My lord, that they have, my lord, with retrospective effect from 12th of February 2023.
Even today. Increment, how could that stop?
My
the
lord, now
increment?
this situation, my lord, this
The getting
situation,
charges are causing all these hindrance, and
kindly takes up.
Just a minute.
it is not his money. Why you are so worried? It is not his money.
And you are relying upon Mr.
Yes,
Jahan,
my lord.
you are
Three-
relying upon
Three and the
6,
proviso.
Rule 6,
Rule 6,
Rule
3 and
6.
proviso.
3 proviso.
Yes.
First proviso to Rule 6(3).
Yes.
Provided that during suspension period, no annual increment, career advancement scheme benefit, revision of pay benefit, or any other benefit declared by the government final pension gratuity shall be allowed other than subsistence allowance. What is the suspension period? Suspension period is for the period
Just clause
of
3.
12th
But
February
that's a clause 3.
2023 to 25th
But that's a clause 3.
February
That's a clause 3.
2023.
That's a clause 3.
Yes,
Clause 3 says if the disciplinary proceeding is not initiated or
it
contemplated.
is not a case of disciplinary
Yes,
proceeding.
next line.
Yes, please.
Once he is released, has been released on bail, the concerned teaching or non-teaching employee may be allowed to resume his duty. So he was allowed to resume his duty.
Suspension order goes.
Now
If suspension order would have been continued, he would not have been allowed to resume his duty.
Yes.
Now, kindly clarify this situation, my lord. Clarify this situation. According to me,
Is it
Since-
necessary to clarify?
my lord, according to me, my lord, since he was placed under suspension and he could not work or he didn't work for a certain period,
For which, during which period?
From my lord, 20th April 2024 to September 2024. This is the disputed area.
20th April 2024
Four.
to
Till my lord September 2024. Now this period he didn't work due to existence of suspension order, which has been withdrawn subsequently. Now I am of the
20th of April till 10th September 2024.
yes,
The
my lord,
suspension order was not revoked.
was not revoked. So for this period, my lord, my submission before lordship is not entitled to have his full salary at present.
20th April to 10th September.
10th September.
Yes, Mr. Bhattacharya, during this period you did not work. Because the reason is this, that you are not to be blamed for that, because this suspension order was issued on 8 April 2024 and board took time to take decision with regard to revocation of suspension, and suspension was revoked on 10th April 2024. So since there was no revocation of suspension, school could not allow you to
But as per the
discharge
provision,
duty.
as per the
So
provision-
therefore, what can be done that during this period, since you did not work, you are not entitled to get salary, but this period will be treated as a regular period while computing your service benefits,
My lord, as
subject to the final outcome of the criminal procedure.
Yes, my lord. That would be my submission.
connection with the present proceeding, it is not connected with the school affair.
Absolutely correct.
And law provides.
Absolutely correct.
Once I am
But
released from
how
bail, I
this-
am entitled to join.
But Mr. Bhattacharya, how this court can give direction for payment of salary during the period when you could not work?
I have been prevented from working
Yes,
because of
that's true.
And that
That-
was, the
but-
board has said retrospective benefit to be given to me. The board was quite alert that this has nothing to do with the school matter, school affairs. Unnecessarily, that the issues are being raised. Board has said give retrospective benefit. Date has been fixed. How they can deviate from that order of board? Mixing all these issues are absolutely irrelevant in the context. After board's order, you cannot touch it.
But board has said along with all benefits.
Yes.
Along with all service benefits.
Yes.
But
But it was not the fault on the part of the petitioner
but-
to
but
not
may
to
I-
discharge duty.
may
But
I-
due to, by the dint of the order of suspension,
so my lord, if
delayed order of suspension dated 8 April 2024, petitioner rather could not discharge duty.
Yes.
yes.
So for that, petitioner should not be blamed.
now my
Petitioner should not be blamed. Ultimately, 8 April 2024 suspension order was revoked by the order dated 10th
10th of
April 2024.
Then September 20.
September 2020.
10 September 2024. So during this period,
he
petitioner
couldn't
could
work.
not
Let us accept he
He
couldn't
could have
work.
worked had the board been prompt in issuing a suspension order, then this complication would not have arisen.
Yes. But my lord, kindly consider one
Why
thing.
petitioner will
No,
suffer
kindly
for
consider
that?
one thing
These
also.
criminal proceedings will continue
Now-
for at least 5-6 years,
Now kindly
or
consider.
more than that. And during this period, why
Now, my lord,
petitioner will
Now
be
the all
blamed?
service benefit, if it includes my lord his full
I
salary.
could understand that petitioner was absconding. Petitioner could not
No.
join. That is not the issue.
That's not the issue.
Petitioner joined on 25th February 2023, worked till 8 April,
20th April, my lord, 19th April.
worked till 25th February to worked till 19th April 2024.
Yes.
Thereafter, on 8 April, this order was passed. 8 April order, why it was given effective from 20th of April?
He was communicated to us by a
Later.
memo dated 19th of April.
Yes. So that's why. So the situation is this. Situation is quite complicated.
Yes.
Situation is this, that 12th February taken into custody. Then on 24th February released on bail. Petitioner joined on 25th February. Worked till 19th of February. Then suspension order was communicated with a memo dated 19th
April.
April 2024, and which was given effect to, so far the school authority is concerned, with effect from 20th April 2024. Now, board took time from 20th April 2024 to 10th September 2024 to revoke it. During this period, petitioner could not
Couldn't
join.
work.
Taking this issue into consideration, board directed that allowing the petitioner Ganapati Pore to resume duty along with all service benefits.
And one
You
thing,
have not challenged this order.
and one thing more, my lord. One thing more. Kindly allow me, my lord.
Sure.
My lord, one thing, my lord, kindly. I failed. My lord, no. One thing, my lord, that's troubling me. That's troubling me. How could the board withdraw the suspension with effect from our 12th of February?
You ask the board.
I fail to understand. It should, yes, it should have been from 24th of February. A person when
A period which is to be considered as suspended period from 12th of February to 24th of February.
but this order says that has also been written from our 12th of February.
That is the reason.
If we go by this order, there is no suspension at all.
Writ petition is heard. Affidavit sub is filed on behalf of
Yes.
the petitioner is taken on record. Next paragraph, writ petition is heard in presence of the learned advocate representing the parties. Next paragraph, by presenting this writ petition, claim has been laid by the petitioner for release of arreared dues which accrued due to difference of salary which was payable to the petitioner and subsistence allowance which was actually paid to the petitioner for the period from 20th April 2024. Yes, Mr. Jahan, assist this court
Yes,
while considering the period from 20th April 2024 to 10th of September 2024
Yes.
to 10th of September 2024. Stop. Next paragraph. Petitioner is an assistant teacher in Rothipur, Baroda, Banipit within bracket HS, Poschim Medinipur, who was implicated in a criminal proceeding and taken into custody on 12th February 2023. Stop. Petitioner remained in custody from 12th February 2023 to 24th February 2023 and was enlarged on bail on 24th February 2023. Stop. Petitioner resumed duty on 25th February 2023 as an assistant teacher of the said school. Opore ota diye deba said school. Hereinafter referred to as said school. As an assistant teacher of said school. Petitioner worked post obtainment of bail from 25th February 2023 till 19th April.
Till 20th he worked.
Till 20th April 2024. Stop. President ad hoc committee of West Bengal Board of Secondary Education within bracket hereinafter referred to as board, close bracket board, quote unquote, issued suspension order on 8th April 2024 and same was communicated with a memo dated 19th April 2024 to the school authority.
So accordingly, he was out of job from 21st of April.
Stop. Stop. Due to giving effect to the suspension order dated 8 April 2024, petitioner was placed under suspension with retrospective effect from 12th February 2023 being the date when petitioner was taken into custody. But petitioner could not attend the school On and from 21st April
Yes, ma'am.
2024.
Yes.
On and from 21st April 2024. Subsequently, taking into consideration of the issue, President of the board passed order dated 10 September 2024, withdrawing suspension order with retrospective effect from 12th February 2023, and the said school authority was directed to submit to the board, before the board resolution of the managing committee regarding showing that the petitioner was allowed to resume duty along with all his service benefits with effect from 25th February 2023. So, next paragraph. Mr. Bhattacharya, learned advocate representing the petitioner, submits that the suspension order dated 8 April 2024 was passed, and effect of such order is retrospective suspension for a period from 12th February 2023 till 24th February 2023, since petitioner was resumed to join. Petitioner resumed his duty on 25th February 2023. Reliance is placed on the relevant part of the order of the President of the board dated 10th September 2024, whereby managing committee of the said school was directed to adopt a resolution for releasing all service benefits with effect from 25th February 2020. So, it is the contention of the petitioner at best suspension period of the petitioner should be treated from 12th February 2023 to 24th February 2023, not beyond that. There is another limb of submission which is advanced on behalf of the petitioner, that it is true that he was it is true that he could not function as assistant teacher of the school for the period from 20th April 2024 till
From 21st of April, ma'am.
from 21st April 2024 till
10th September.
till 10th September 2024, but for that no fault is attributable to the petitioner. It was rather it was due to the order passed by the suspension order passed by the board dated 8 September 2024 with retrospective effect from 12th February 2023. Next paragraph. Mr. Sarwar Jahan, learned advocate representing the said school, has drawn attention of this court to Rule 6 of West Bengal Board of Secondary Education within bracket appointment, confirmation, conduct and discipline of teachers and non-teaching staff, close bracket, rules 2018. In order to content that in terms of proviso to Rule 6 within bracket 3, during suspension period, no annual increment, comma, career advancement scheme benefit, comma, revision of pay benefit, comma, any other benefit declared by the government is required to be allowed other than subsistence allowance. Stop. Therefore, the stand taken on behalf of the school authority is petitioner is not entitled to receive difference of salary and subsistence allowance during the period, or difference of salary and subsistence allowance till 20th April 2024.
Subsistence allowance even not paid during the period of suspension. Can you record that?
Stop.
Which period?
Payment going.
Which period?
Suspension.
With 12 days.
Why? Yeah.
According to the school authority, petitioner is entitled to receive
Up to September 24.
those benefits from 21st April 2024, when petitioner again started functioning after the order of withdrawal of after the order of revocation of suspension was passed by the president of the board on 10th September 2024. No, you did not work from 21st April 2024. Now, then when he again resumed duty,
11th of
sentence টা
September.
বলো, বলুন।
After this order of board.
Yes, 10th September. Yes.
Anand.
Now, entitled to receive those benefits from 11th September 2020, from 11th September 2024. Yes. আরেকবার পড়ো সেন্টেন্স।
Date copy. 8/4/24.
On 10th September 2024. Stop. Next paragraph. আচ্ছা, ওপরে যেখানে ওই তোমার কি বলে পিটিশনের আর্গুমেন্টটা রেকর্ড করা হয়েছে, এখানে একটা জায়গায় করে দেবে, ইট ইজ অলসো সাবমিটেড দ্যাট for a particular period of time, subsistence allowance was also not paid to the petitioner.
Not the current increments are being paid to the petitioner.
Stop. Next paragraph. Issue. Having considered the respective submissions made on behalf of the parties, this court is required to determine within which period petitioner is to be treated under suspension in view of the order of suspension dated 8 April 2024 and revocation of suspension order dated 10th September 2020. So, facts reveal that petitioner was taken into custody from 12th February 2023 and he remained in custody till obtaining bail, till enlarged on bail on 21st 4th February 2023. Stop. Petitioner resumed duty on 25th February 2023, but order of suspension was issued by the President of the Board on 8 April 2024 with retrospective effect from 12th February 2023. Stop. Subsequently, President of the Board issued revocation of suspension order dated 10th September 2024. Stop. Due to delay in issuance of suspension order, petitioner could not function as assistant teacher for the period from 20 April or 21st April.
All right, from 21st April.
From 21st April 2024
till 10th September
till
2024.
10th September 2024. Stop. But prior to that, petitioner worked from 25th February 2023 till 20th April 2024
And got his salary.
and received salary.
Without increment.
Stop. Stop. While issuing revocation of suspension, VDA order dated 10 September 2024, perhaps President of the Board has taken the issue into consideration, resulting in giving direction upon the said school authority to adopt a resolution of the managing committee in order to allow the petitioner to resume duty with all service benefits with effect from 25th February 2023. Stop. Such decision of the President of the Board has not been assailed by the school authority. Stop. Facts also suggest that petitioner did not attend the school from 21st April 2024 till 10th September 2024 in his own volition. Rather, due to delay in taking steps by the board, petitioner was not permitted to resume duty, was not permitted to function as assistant teacher of the said school, for which he should not be unnecessarily penalized upon denial of monthly salaries during this period. Next paragraph. Taking consideration of entire gamut of the issue and the order passed by the President of the Board dated 10th September 2024, respondent authorities including the authority of Rothipur, Baroda, Banipit within bracket HS Paschim Medinipur are directed to release arrear salary adjusting subsistence allowance,
If any paid. It was not
adjusting
paid.
subsistence allowance if paid to the petitioner for the period from 21st April 2024 till 10th September 2024 within a period of fortnight from the date of communication of this order.
Along with the incremental benefit, I am entitled to 2 days, no suspension against me.
Stop. along with incremental benefits. देखिए sentence एक बार पढ़ो तो last. Comma.
No, date was 25th February 2023 as per our board's order, with effect from 25th February 2023.
No. You stopped working from 21st April 2024, according to the school act.
That was due to suspension.
Yes.
Due to suspension. And
But prior to that, you received salary.
prior to that, I received salary. But the
Then-
board has said
Till 20th of April, you have received
What?
salary. देखिए बोलो. 21st. Now, along with incremental benefits. It's fine. With the aforesaid direction, writ petition stands disposed of. Urging the report.
what if trouble?
Good.
A lot of trouble to your very sorry, Vala, what should happen?
He has been saved by the order of.
Yes.
Normally,
You have not challenged.
normally there is revocation of suspension. Here it's a withdrawal of suspension.
অঞ্জলির সঙ্গে কথা বলে দুটো বই আনিয়ে নাও.
And may I get back my book? Extremely grateful, Malad.
But this book will be required.
Yes, Malad. Kindly.
I'm keeping it after
take it.
putting signature 1 or 2 days thereafter.
Yes,
I
yes,
will
yes.
get it.
I have another copy.
দেখে ওটা ফ্ল্যাগ করা আছে কিনা দেখি. Next matter.
Item number 5.
Item number 5, my lord, interest of gratuity, my lord. In this matter, my lord.
Issue. List the matter under the appropriate heading in the monthly combined list of March 2025. Next.
Item number 6.
6 time for the state, my lord.
I am secondary board election.
She was directed the petition to be entered, whether the petitioner is a single teacher or not.
Just it.
It is, sir.
Yes.
Well, as per the instruction, the petitioner is a single teacher, my lord, and a surplus teacher. There is 20 students in the school and 2 teachers and 1 non-teaching staff, my lord.
But there are several petitions, applications you have made for transfer.
My lord.
As it appears from page 18. Yes. What was your last application for transfer?
Last application is a 16 December 2024, my lord.
No, it is probably on 16th, 11th February 2022.
As per my instruction and as per my petition.
Come against, consider serial number 4, page 18.
11/7/2024.
Who is appearing for the commission?
Commission?
No, I'm secondary.
Well, kindly come to page.
But why have you served upon the commission? West Bengal Central School Service Commission?
Yes, my lord. Just a second, my lord.
No, commission has not been made party.
Sir, commissioner has been made party, my lord.
West Bengal School Service Commission.
No.
Oh, my lord.
President-
Not made a party.
Yes, Secretary West Bengal School Service Commission
Made a party.
has been made party.
Commissioner has not.
Commissioner, no, commissioner has no authority now. Now the Secretary West Bengal Central School Service Commission has been made party. Show me that you have served notice upon the commission. Because it is to be decided by the commission ultimately. If alternative arrangement is made, show me how you have served upon the commission. Not commissioner, commission, West Bengal Central School Service Commission. Show me that you have served upon the commission.
Can you fix the matter tomorrow, my
Why
lord?
you have not served? Yes, whether you have served notice upon the commission, West Bengal Central School Service Commission. Why not? Commission secretary has been made party.
Yes, yes, I have served.
Show me that you have served upon the West Bengal Central School Service Commission. Are you appearing in this matter? No. Yes.
কোনো গাছিস ছয় আসিস
Tara, Tara, Tara.
Commissioner কে করেছে? Commissioner
But we have not made him a party, man.
Yes. Secretary West Bengal Central School Service Commission has been made party.
Response number
Response number 5.
Yes, yes.
How you have served?
Well, executive service is there, my lord. On the last occasion, I have handed over. I'm sorry, my lord. I'm
এটা খুলে দাও তো।
distracted. দেখি। On the last occasion, lordship was of the view that whether there is a single teacher
No,
or
no, now it appears that the commission is not represented.
But one minute, my lord.
এদিন মনে হয় না পেয়েছে না না এদিক ছিল না আমার ঘর দেখে দেখে দিচ্ছি এই তো
Mr. Saurabh
সৌরভ
appeared.
মিত্র সৌরভ মিত্র was last of it
The last occasion, he appeared.
সৌরভ মিত্র was
Only school is not represented.
Yes, lord.
Right.
Only school is not represented. Mr. Mitra appeared on the last occasion virtually. My lord, page number 7. Subject to correction.
Yes.
My lord, on the last occasion, lordship specifically asked me to inquire whether it's a single teacher or not. My lord, single teacher plus surplus teacher. There are total 20 students in the entire school. There are 2 teaching staff and 1 non-teaching staff. I inquired from my client, my lord.
So if there is 2 teaching staff, then 3rd February 2022 notification 9 AC is not applicable.
Lordship,
There is a specific notification of 3rd February,
February.
3rd January 2022, 10 AC.
3rd
Now,
January.
if the number of teacher is less than 5, then local arrangement cannot be made.
That is there, my lord. But the fact is
So
that
how this can be considered?
Lordship,
You place the relevant notification 3rd January 2025 on the next date. If
Lordship.
the number of school in a school, if number of teachers in a school is 5 or less than 5, in that event, local arrangement cannot be made.
Lordship. But 3rd January 2022.
3rd January 2022 notification number 10 AC.
Number 10 is. Lordship.
2025 to 25
2022.
At the time of call, learned advocate representing the petitioner has prayed for accommodation to come better prepared. Next paragraph lists the matter under the same heading on 11th March 2025.
Lordship.
Next.
Great.
Item number 7.
Affidavit of service, I'm for the petition. Well, I'm for the commission. Lord, page 82 is the status. For better reading, my lord, page 85 your lordship can take. 82 may not be.
What about other respondents?
I've served.
You are for the state.
And I'm for the commission.
In January.
Served. School has received.
School has been served on 11th February.
Yes.
Yes, what is the matter about?
My lord, though have been returned on single subject teacher ground, page 82 is the status, my lord. It may not be legible, my lord. Your lordship can take page 85 for better reading.
Application is due. So you have grievances against the school authority. Yes,
but
10th
previous
October, 9th October 2021.
previously commission had returned on the same ground. So it is on the basically, yes, my lord, it is against the school authority at present. As
Now
per-
you are a single teacher in this.
he is not a single teacher. I've got the information. He's not a single teacher. There are three.
The school is saying you are the single
Single
teacher.
teacher. There are three teachers.
Serve another notice and come
Very good.
upon the school. At the time of call, no one appears for the for the affidavit of service filed on behalf of the petitioner is taken on record. Stop. In spite of service of notice. Who is for the commission? You are for the commission.
I'm for the
In spite of service of notice. Authority of it is Mohirampur or Monirampur?
Mohirampur.
Mohirampur High School within bracket HS.
Mohirampur. MHI. Mohirampur.
High School within bracket HS. Being respondent numbers 7 and 8 are not represented. Next paragraph. Learned advocate representing the petitioner submits that though school authority endorsed on the portal in connection with transfer application of the petitioner that the petitioner is a single teacher in the subject in the school, but this is incorrect fact. Stop. Next, having considered the submission made on behalf of the petitioner, court desires to hear the aforesaid school authority. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the authority of Mohirampur High School within bracket HS, being respondent number 7 and 8, enclosing copy of this order by 7 days from date and file further affidavit of service on the next day. Next paragraph. It is made clear if on the adjourned date school authority remains unrepresented in spite of service of notice, matter shall be heard in absence of the school authority. Next paragraph lists the matter under the heading motion on March 2020.
My lord, I will not, possibly I will not be available on that point of India after 16th, my lord, subject to lordship's consideration.
Where are you going?
Possibly I'll be in the North Bengal circuit bench at that time. So possibly, my lord, at that.
On
any day, subject to lordship's convenience after 16th.
On 24th March.
I'm grateful. I'm extremely grateful to your lordship. Lord, affidavit of service be kept with grateful to your lordship.
আমি বলেছি মনে হয় 24 spite of service.
24. Grateful. Hey.
Item 6,
My lord, I'm for the petitioner. This is my service. School has refused to accept. I've handed over the envelope which denotes refused.
They refuse to accept.
That is on the envelope, my lord. It is written as refused. This is also on the school page 91. Page 91. SSC returned on the ground of single subject teacher initially. Following that trail, the school returned my application on the same ground.
Yes, page 91.
Yes, my lord, kindly take. Serial number 5 was the initial rejection by the commission on single subject teacher ground,
Where is written?
and that was followed.
So you are a single subject teacher.
Political science. So while usually one sanction strength only. That is the difficulty. There could be never a double teacher in that school in that subject. Your lordship knows that what is the fate of 3rd January notification. That in internal loop, this infinity loop will keep on going. Because in every school there are one political science teacher. Usually, in most of the cases.
Issue. You serve another notice upon the school authority in terms of the court's order. Let me see. Who is appearing for the state? State has a role to play if it is a single teacher. Serve notice upon the learned advocate also, representing the state. That I do not do. Today he is not there.
Yes, definitely I'll send notice.
Affidavit of service filed on behalf of the petitioner is taken.
আজকেই রেডি করবি আজকেই করবি
On perusal of the affidavit of service, it appears. Now, learned advocate representing the petitioner submits that the school authority or that the authority of Tildanga High School within bracket HS Murshidabad refused to accept the notice. And the envelope along with notice dated 30th January 2025. Why the envelope is empty?
No, it was there because I had.
No, but you should not have taken it out.
Yes, possibly.
Should not have taken it out. Why you have done so?
Because my lord, I
The other side may appear on the next date and say that the envelope was empty.
the gram is written. The weight of the document is
Maybe,
written in the.
but you are not supposed to do this.
I checked. Actually, I checked which
It
petition.
is not permissible.
Right. Inadvertently, I have done it because I had to check which.
No, not at all. The entire envelope along with the petition is required to be
Has to
there.
be. Yes, my lord. I checked which petition came
You
back.
should not have taken it out.
My lord,
And send the copy to other party.
No.
No, that is not the
I had
procedure.
to check which writ petition came back. That is
The entire envelope along with the
petition.
inside material should be there.
Yes. But the gram is mentioned. The weight.
If other side disputes your submission, then it may be said that this envelope was empty. That was the reason it was not accepted.
Possibly they
In spite of other things, we are saying that the weight, that is the secondary aspects.
Yes.
But the envelope is empty. Don't do it.
No, I will not do it. I will not.
Don't follow this procedure in future.
No. It is a mistake on my part, my lord. I will not. Do it.
কি বলছিলাম? Is enclosed to the supplementary affidavit. Is enclosed with the affidavit of service. Is enclosed with affidavit of service. Next paragraph. Question is next paragraph. Petitioner made application for transfer on Utsosi portal. When you have applied last?
Lastly, on my lord,
25th September.
25th September.
On 25th September 2021. But the school authority did not process the application of the but the authority of Tildanga High School within bracket HS did not process the transfer application of the petitioner, perhaps on the ground that petitioner was found to be a single teacher. Next paragraph. Petitioner is stop. Single teacher. Court desires to stop. Single teacher. Next paragraph. Petitioner has grievance against the aforesaid school authority. Stop. Court desires to hear the school authority. Stop. Next paragraph. Knight advocate for the petitioner is directed to serve another notice upon the authority of Tildanga High School within bracket HS Murshidabad, being respondent number 7 and 8, enclosing copy of this order by 10 days from date and file further affidavit of service on the next date. Next paragraph. List the matter under the heading motion. আগেরটা কবে করলাম দেখো তো ওরা কি ডিফিকাল্টি আছে under the heading motion
24th
on 24th March 2025. Next paragraph. If the school authority remains unrepresented on the next date, in spite of service of notice, writ petition shall be heard in absence of the school authority.
I'm grateful, Your Lord.
Please call the list. Item number 9.
Who is for the state?
The matter was filed by the instruction secondary school. Accordingly, one of the representations were made, my lord, so that then the matter was, my lord, drafted accordingly. And after, my lord, the matter was, my lord, served upon then the school authorities. My lord, they, my lord, informed, my lord, that it's a primary school, my lord, so therefore, my lord, all the representation, my lord, sent it to the appropriate. But,
So what do you want?
my lord, the matter should withdraw and, my lord, filed it.
At the time of learned advocate, learned advocate representing the petitioner prays for leave to withdraw the writ petition with liberty to file afresh. Next paragraph. However, respondents are not represented. Next paragraph. Considering the submission made on behalf of the petitioner, writ petition stands dismissed as withdrawn with liberty to file afresh with better particulars on self-same cause of action. Urgent Xerox certificate copy. Or to act on a server copy of the. Next.
Item number 10.
Item number 9 for the estate led by Mr. Vishwavata Baswagi.
Yes.
Lordship, on the last occasion, I had applied for affidavit of service as against respondent 8 and 9 not given. Lordship,
Why not?
Lordship, because the service launch was not completed. Lordship, I checked yesterday, it has been completed. Lordship, respondent number 8 is the administrator.
Who is the petitioner?
Lordship, the
Who are the
petitioners before your lordship are the guardians of the students who are studying at Durbachoti Milan Vidyapith. Lordship, what has happened? They are praying for conversion of their school.
How the guardians are interested for conversion of the school?
Lordship, guardians are interested because the managing committee in the said school has not been functioning since 2019. As per the order of a coordinate bench, Lordship, if I may, Lordship, if I may
matter is heard in presence of the learned advocates representing the petitioners and state respondents as well as West Bengal Board of Secondary Education. কি বললাম সেন্টেন্সটা? না, yes, Board of Secondary Education. Next one. Two guardians of a school have approached this court with a present writ petition seeking direction to convert the school into a government-sponsored institution. And also for reconstitution of managing committee in the school in question. Next paragraph. Considering the nature of prayer made in this writ petition, there is no scope for passing an interim order. Next paragraph. Respondent shall be at leave to file affidavit in opposition to this writ petition by 4 weeks from date. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioners shall be at liberty to mention the matter for hearing after the time fixed herein above for exchanging affidavits. Next paragraph. Learned advocate for the petitioners is directed to communicate this order to the non-appearing respondents by 7 days from date and file further affidavit of service on the next date. Next.
Item number 11.
At the time of call, accommodation has been prayed for on behalf of the petitioner on the personal ground of the learned advocate. Next paragraph. However, respondents are represented by learned advocate. Next paragraph. List the matter under the heading motion in the monthly combined list of March 2025. Next.
Item number 12.
Person additional increment for that responsibility after upgradation of secondary school.
There was made, ultimately DI referred to the Commissioner of Education, but no decision was taken.
Where is the prayer, by which order letter prayer was referred to the, forwarded to the Commissioner of School
Paragraph,
Education?
Page 49 and 50.
There is an order by a coordinate bench judgment.
have annexed-
Where is that order?
Melody, that is the
After that, my lord passed
Page
an order.
71.
page 61, 71 also.
Petitioner has retired in the meantime. When retired?
Retired Melody, during the pendency of the retired 30th November 2024.
30th?
October 2024. Issue has been issued, but the claim of the petitioner's melody has not been
issued.
My lord, just give me 2 minutes. Well, I've got an instruction from the DI, and in another judgment, my lord passed an order regarding this matter. I have to give.
What order I have passed? Tell me. What order I have passed?
Directed DI to consider the representation.
Yes. He is also seeking same order to be, decision to be taken by the commissioner, not by the director. District inspector.
Grateful to me.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner was an assistant teacher or was an headmaster.
Headmaster.
Petitioner was headmaster in a government aided higher secondary school.
higher secondary school.
Upgraded high secondary.
Government aided higher secondary school who retired on superannuation on 30th November 2024. Stop. Since petitioner manned the post of headmaster in a higher secondary school, prayer is made in this writ petition for sanction of 3% additional increment. Stop. It is also submitted on behalf of the petitioner that issue has already been decided by a coordinate bench on a writ petition being WPA 17960 of 2019 within bracket Ashish Kumar Sarkar and others versus State of West Bengal and others, with a judgment dated 7th May 2024. Stop. Petitioner it is stop. It is contended that petitioner is entitled to get. It is submitted that the issue is covered. Issue is covered by the judgment passed in Ashish Kumar Sarkar Supra. Next paragraph, state respondents are represented by learned advocate who submits that the issue is pending before the Commissioner of School Education, West Bengal. And in this regard, attention of this court has been drawn to memo dated 3rd June 2015 issued by the District Inspector of Schools within bracket AC close bracket Purulia, which is at page 50 of the writ petition. Next paragraph. Having considered the respective submissions made on behalf of the parties, writ petition stands disposed of, directing the Commissioner of School Education West Bengal being respondent number 2, respondent number 2 to decide entitlement of the petitioner to receive 3% additional increment for manning the post of headmaster in a higher secondary school till the date of his superannuation on 30th November 2024 by passing a rescind order within a period of 12 weeks from the date of communication of this order. Stop. Why stop? Petitioner shall be granted opportunity of hearing before taking such decision. Next paragraph. The decision to be taken by the commissioner shall be communicated to the petitioner by 10 days thereafter. Next paragraph. While taking decision, commissioner shall follow the ratio of Ashish Kumar Sarkar Shukla. Next paragraph. Disposal bole diyechi dekho to. Writ petition stands disposed of, urging Xerox certificate.
The instruction should be kept in the
Not
record.
required. I have not called for any report. It is for your consumption.
Grateful to me, Lord.
12 weeks.
Yes, you have retired in 2024. What you are doing? Don't open your mouth too wide, Mr. Jana. After retirement, seeing the order, you are coming.
That's true. Grateful to me, Lord.
Yes. And receiving all benefits.
After receiving all benefits.
Yes.
Item number 13.
I picked up for the petition. The petitioner seeking transfer. The status of his application, page 44.
Page 34.
44. Justice Melody, I am placing serial number 6 my application. Because the last application I withdrawn because on medical grounds, my lord, that is not covered under the Rule 4A.
Why so many applications?
That was also when it reached to the School Service Commission. School Service Commission returned that his application, again applied. The last application, serial number 6.
This is an application on medical ground.
No, on 6, my serial number 6 on general ground.
Prior to that, it was on medical ground.
No.
Why this was rejected? All applications are on.
Last application on medical ground, but not within the purview of the disease mentioned in 4A. That is why he withdrew that. Last application, serial number 2. But the 6, I am placing that the 6, that is the DI returned his application, follow the.
But after 6, when you have applied for transfer on medical ground, that is 22nd of March 2022, after your application on 19th February 2022, then your previous application goes.
No, but the
Relinquishment of right.
second application,
Relinquishment of right.
Yes.
I withdrawn. Withdrawn because with the medical ground I applied.
So therefore, subsequently you cannot press this application for transfer.
But
You have
that-
waived your claim relating to consideration of this application dated 19th February 2022, since subsequently you have applied for transfer on medical ground. Both the applications cannot be considered. When you have applied for transfer on medical ground on 22nd of March 2022.
that 22 March 22, I withdrawn that because the medical ground is not the purview of the.
But you have applied.
Applied,
At
my
the
lord,
very
alternative
moment you have,
and
at
so
the
many
very
applications.
moment you have applied for transfer on medical ground, your previous application goes.
No, my lord,
No, that cannot be kept
19th
alive.
February, that can be proceeded, my lord.
No.
Because the 19th February, my application is, my lord, returned on that,
So
on the
22nd March 2022 is on medical ground.
medical ground. Only 10th, relying, my lord, the notification of 10 AC, my lord, 3rd January. That is the, my lord, reason. So, although, my lord, I have again applied, my lord, so many applications are returned, even from the School Service Commission without any reason.
See, you applied for transfer on general ground on 19th February 2022.
Yes.
Now, subsequently, on 22nd March 2022, you applied for transfer on medical ground.
That was withdrawn.
This was withdrawn on 6th April 2024. So, during the period from 22nd March 2022 to 6th April 2022,
School has kept pending.
both applications cannot be kept alive, because at that very moment when you are applying for transfer on medical ground, your previous application does not survive.
Yes, my MLD that has been withdrawn.
Affidavit shall be filed on behalf of the petitioner is taken on record. Next paragraph. By presenting this writ petition, prayer is made for consideration of previous transfer application dated 9th February 2022 made by the petitioner on
19th February, Your Lordship.
9th February 2022.
19th.
February 2022 made by the petitioner on portal on the ground of distance. Stop. However, on perusal of the status of however, on perusal of a document at page 44 of the writ petition, it appears that petitioner applied for transfer on general ground on 19th February 2022. Stop. During pendency of the said application,
Sunirman Mandal.
তার সেন্টেন্সটা বলো। তার আগে ডিউরিং পেন্ডেন্সিটা কেটে দাও।
সাবসিকুয়েন্ট অ্যাপ্লিকেশন ছিল যেখানে নিজে উইথড্র করেছে, এবার আগেরটা যদি রিটার্ন পার্টিকুলার অ্যাপ্লিকেশনটা কি করে সার্ভাইভ পুরো জায়গায়
Applied for transfer on general ground on 19th February 2022. Stop. Said transfer application was forwarded by the school authority where petitioner was serving to the concerned district inspector of schools within bracket AC for taking steps. Stop. The district inspector of schools within bracket AC on 8 March 2022 returned the transfer application dated 19th February 2022 to the school authority since the disease which was indicated in the transfer application
Since and directed to follow the notification of 10 AC of 3rd January.
single teacher.
Single teacher.
হ্যাঁ কি বলছিলাম?
Ratio. Alternative arrangement.
School authority, since petitioner was found to be a single teacher in the subject in the school. Yes.
The 3rd January, 10 AC is with respect of ratio, and where in a school strength of the teacher is below 5 or below 5.
He was a single teacher.
10%.
10 AC. 9 AC is single teacher.
আরেকবার পড়ো, right. না, since বাকিটা কেন? Since it was found by the authority that notification dated 3rd January 2022 being number 10 AC was applicable considering the number of teachers available in the school. That was 5 or less than 5. School authority of the petitioner subsequently on 7th March 2022 sent back the transfer application to the applicant.
On 17th March.
17th March 2022 sent back the application of the petitioner. Send back the application of the petitioner to the petitioner. Or send back the application to the petitioner. Send back the application to the petitioner. Stop. Petitioner did not. Petitioner accepted the decision taken by the authorities that transfer application dated 19th February 2022 made on general ground was not found to be accepted a decision of the authority, accepted a decision of the authority whereby transfer application of the petitioner dated 19th February 2022 was refused to be considered without questioning such decision by taking necessary steps in accordance with law. Subsequently, petitioner made application for transfer on 22nd March 2022 on portal seeking transfer on medical ground, which was withdrawn by the petitioner on 6th April 2022. Stop. It is submitted by the learned advocate representing the petitioner that the disease indicated in the transfer application was not the specified disease in terms of the relevant transfer rules. Stop. Next part. Now petitioner prays for revival of his previous transfer application dated 19th February 2022, which at this stage is found to be impermissible, since petitioner accepting the decision of the concerned respondent authorities not to process the said transfer application dated 19th February 2022 made subsequent transfer application on 22nd March 2022 on a different ground, that is medical ground. Stop. Next paragraph. Hence, the writ petition stands dismissed. Urgent xerox report. Get free.
Item number 14.
I'm for the state, madam.
Pending before the year. Railway extract. My lord. All application, few application, all application on the ground of distance. Last application on 18th of November 2022, and full authority forwarded the year on 12th of November 2020. But previous application backed by the commission.
Just a minute. Now it is pending before the DI.
Only needs to forward the commission
It is on distance. Distance ground. Now, what is the date of your last application? 8 April.
8th of November 2022.
Why previous application dated 8 April was refused?
Yes, refused by the commission. That prayer is returned serial number 7. Prayer is returned due to low rank in the papers. So my lord, that point already.
So your last application is 8 November 2022.
But school or neither objected school.
Yes, school issued NOC.
NOC.
12 November 2022.
And before this application, another application was made on my lord, April.
Yes, sir. That has affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner prays for direction upon the District Inspector of Schools, SC, Paschim Medinipur being respondent number 4, to process her transfer application and forward the same to the West Bengal Central School Service Commission for taking final decision. Stop. An application for transfer was made on portal on 8 November 2022 an application for transfer was made on portal on 8 November 2022 on the ground of distance in between the present school of the petitioner and her place of residence. December 2022. Sealing mistake. Stop. The school authority where petitioner is presently serving issued no objection certificate and forwarded the transfer application on 12 November 2022 to the concerned district to the respondent number 4. To respondent number 4. Stop. The grievance of the petitioner is, after receipt of transfer application through portal on 12 November 2022 till date, respondent number 4 has not taken any steps for forwarding the transfer application to the West Bengal Central School Service Commission. Who is for the state?
Well, I'm for the state. My lord, actually that last application when the petitioner have made, that Utsashi portal had already been suspended.
That is not a ground. Court has decided. Next paragraph. Respondents are represented by learned advocates. Stop. It is submitted on behalf of the state respondents that due to suspension of portal, steps could not be taken on transfer application of the petition. Next paragraph. It is settled. It has already been decided that suspension of portal ought not to be a ground to deny the right of the petitioner, right of applicant teacher to be transferred in terms of statutory provisions. Therefore, respondent number 4 is directed to forward transfer application of the petitioner dated 8 November 2022 to the West Bengal Central School Service Commission by fortnight from the date of communication of this order. Stop. After receipt of transfer application, Chairman West Bengal Central School Service Commission being respondent number 3 is directed to decide the transfer application of the petitioner by 6 weeks thereafter in accordance with law, and the decision shall be communicated to the petitioner by 10 days thereafter. Next.
8 weeks.
No, by fortnight it will be
Fortnight by the DI.
No. 6 weeks. Stop. It is made clear that transfer application of the petitioner shall not be rejected on the ground of suspension of portal. Next paragraph, the writ petition stands disposed of. Urgent Xerox certificate copy. Next.
Item number
All other matters up to 23 be placed in the monthly list of March.
Very good.
Madam, it is a hard, next matter hard skill.
Yes, maybe.
Just accept that.
Yes.
Madam, this is the second round of litigation. Reason order passed by the.
This is for the school authority.
Madam, I have served.
How you have served? Show me. দেখো এই দাও এটা দাও
Madam, by speed post, both the school has served on 1st of February. Delivered, item delivered, page number 5 and 6. Pursuant to my lord's direction.
Why two school authorities have been
Previously,
impeached?
when I started the course of master degree, I was in one school. Subsequently, I got transferred, and by taking leave of that second school, I completed. That is why I went to two schools.
Then the school authorities are required to be heard. There is a change of school.
It is the second.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. In spite of service of notice, school authorities of Rahimpur Novogram High School, Jongipara and Purbo Chandrapur Chandmoni Shiksha Bhavan within bracket HS, South 24 Parganas, being respondent numbers 5 and 6 are not represented. Next paragraph. The learned advocate for the petitioner is directed to serve notice upon the aforesaid school authorities
5 and 6, my lord.
enclosing copy of this order by 10 days from date and file further affidavit of service on the next day. Next paragraph. List the matter under the heading motion on March 2025. Next paragraph. If on the next date, in spite of service of notice, school authorities, both the school authorities remain unrepresented, matter shall be heard in absence of the school authorities.
Yes.
Item number 16.
Lord, I am for the commission.
Lordship, I am for the appearing for the state lord.
Transfer on the ground of distance. Matter status is page 19. Page 19 is the status. Matter DI rejected
When the school authority has been served. A to Dautu.
I am the teacher of my lord geography in each section.
You are a single teacher.
In geography in each section. There are 3 teachers in normal section. Right? Single teacher definition is the
No, but in higher secondary section, all teachers cannot take classes of geography
definition.
unless until the teacher is having postgraduate degree in geography.
There is no postgraduate.
Then
The definition of single teacher is with the resultant vacancy in the
problem is this. A teacher in higher secondary section can take classes in normal section. But a teacher of normal section, all teachers of normal section cannot take classes in higher secondary section.
I bow down, but here has not exercised 3rd January.
That is a difficulty. If you have a case that there is a teacher in normal section having requisite qualification to take classes in higher secondary section, then this court can pass an order.
There is no high secondary teacher, high secondary single teacher. I have the MA qualification. But the three other teachers in normal section 0, they have
Do not have
BA.
postgraduate qualification.
That is true. So why not 3rd January? It will be considered a boundary interest of the education. But definition of why not as per rule is otherwise. Single teacher. The resultant.
But the purpose of these notifications are different. Affidavit of service filed on behalf of the petitioner is taken up. Next paragraph. When you have made application 15 November,
1st of November 2021.
Petitioner made application for transfer on 1st November 2021 on portal on ground of distance in between the present school of the petitioner and his place of residence. Next paragraph. Now, stop. Grievance of the petitioner is on 15 November 2021, District Inspector of Schools AC, Birbhum, being respondent number 4, forwarded the transfer application of the petitioner or send back the transfer application of the petitioner to the authority, to the school authority where petitioner is presently serving, with an endorsement that the transfer application needs to be kept with the school authority till alternative arrangement is made. Stop. It is submitted on behalf of the petitioner that he is a single teacher of geography in higher secondary section in the school. Therefore, notification dated 3rd January 2022 is required to be followed for ensuring alternative arrangement in the school of the petitioner in order to facilitate his transfer. However, respondent number 4, without taking steps to find out alternative teacher for making local arrangement in the school of the petitioner, wrongly sent the transfer application of the petitioner back to the school authority. Stop. Next paragraph. Respondents are represented by learned advocates. It is submitted on behalf of the respondents. Since petitioner is a single teacher in geography in higher secondary section, and there is no other teacher in the school, there is no other teacher of geography in normal section of the school who can take classes in higher secondary section. Petitioner needs to be considered as a single teacher in the subject in higher secondary section of the said school. Stop. Therefore, petitioner is required to be. Therefore, respondent number 4 is required to take steps in terms of government notification dated 3rd January 2022. Next paragraph. Having considered the submissions made on behalf of the parties, writ petition stands disposed of, directing the District Inspector of Schools AC Birbhum, being respondent number 4, to make an endeavor to find out willing teacher of neighboring school who can man the post of the petitioner temporarily till regular incumbent is appointed in the resultant vacancy to be created due to transfer of the petitioner. Stop. If such arrangement is made on finding willing teacher, petitioner shall be transferred in accordance with law. Urgent Xerox certificate copy. Next.
Much abridged. Item number 17.
I am for the commission.
And for the state respondent.
Yes, art on the school on 4th of February. That is.
Page? Page 17.
Page 25.
25 is the status, last application on the ground of scholarship ground pending before the DI. Medical verification already done.
Who is for the state?
I am for the state respondent.
Why?
My lord, instruction from DI School of Machine.
Yes, you read the instruction and make submission. I have not called for any report. It's a new trend, I find, nowadays. Whatever is communicated from the officer's side, that is placed before the court without making any submission going through that communication. It's like case diary in bail matter, placed before the court for consideration.
Yes. Suspension of the portal was based on notification issued by.
You have not read this communication in your chamber yesterday night. That is expected from you. Yes, what is the reason that DI did not take any steps?
My lord, his application transfer had already been taken into consideration and a medical board was duly constituted to examine the health of the wife of the petitioner in the terms of provisions of West Bengal School Service Commission, jail and transfer of special ground and reconciliation rules 2015 as reflected from para 7 of this writ petition.
He will make submission in this fashion.
My lord.
Whether the what is the medical report? Nothing is produced.
তোমার রিপোর্টে কি মেডিকেল আছে সেটা দেখতে
Medical report, my lord, done. Para 19, page number 19 and 20.
Of your bunch of papers or the writ petition?
Writ petition. My lord, instruction.
In the situation.
No other medical, no medical report. My instruction.
Mr. Ghosh Chaudhary, any medical report are you aware of?
My lord, medical done by the CMH, but report I have not filed.
So what is the medical report?
No.
Then what is your instruction? Why the DI has not forwarded it to the commission for such a long time?
So this is policy state. The petitioner has need.
Sometimes
The
written
the
instructions for filing affidavit in opposition is placed before.
My lord, notification. Suspension of the portal was based on notification issued by the done by the governor.
So say so that due to suspension of portal, that the transfer application could not be forwarded. You are sitting for such a long time, you could have perused this.
Since, my lord, may I make one submission? Since there is a specific abutment that CMOH, my lord, petitioner has appeared, let the report, my lord, be.
No. I will direct that if the report comes in favor of the petitioner, that will be sent.
Yes, as you
Only reason is suspension of portal.
Yes.
Otherwise, DI would have said that the report is adverse.
Yes.
Medical report is adverse.
Yes.
That is not the instruction your learned friend representing the DI has got.
No report is there.
At least as I find from the submission made by you.
No report is there.
It is expected that this is the position. Thereafter, I do not know. Yes, what is the date of your application?
The last application on 26th of November 2020.
What about the previous applications?
Previous application, my
You are
lord,
eligible under
10%.
previous application was on the ground of distance.
Distance.
10% was applied.
10% applied. But my lord,
Now, why this was rejected on 14th May 2022?
14 May.
And then 26 November 2022, within a period of 5 months, 6 months, you became ill.
My
Yes.
round of it, my lord, why medicate of
By how it is possible? Within a period of 5 months, you developed ailments.
in that scenario, my lord, I only ask
Whether these medical reports are being procured
no, procure whether that
by payment of money. It appears so.
they can, my lord, they can apprise the court that whether, my lord, justified or not.
According to sweet will, a person or his wife is becoming ill, indisposed. And see the timing that it was rejected on 14th May 2022. On 26 November 2022, another application for on medical ground.
Spouse medical.
In that whether that
Issue.
whether that
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner made application for transfer previously on the ground of distance in between the present school of the petitioner and his place of residence. Stop. Same was rejected on 14th May 2022 since petitioner was not found to be eligible under 10%, found to be eligible on applying embargo relating to 10% of the existing teaching strength of the school as contemplated under Rule 5 within bracket 6 of the, it is Rule 5 or 6 or 6.5?
6.5.
Rule 6 within bracket 5 of the transfer rules of 2015. Subsequently, on 26 November 2022, a transfer application was made.
Rule 5.6.
5.6. A transfer application was made. A transfer application was made on medical ground. Disclosing wife of the petitioner became ill. Stop. Question arises, next paragraph. Question arises, if wife of the petitioner was suffering from ailment, why previously transfer application was not made on medical ground? Next paragraph. Issue needs to be decided on exchange of affidavits. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto by 4 weeks from date. Stop. In the affidavit in opposition, the district inspector, the concerned district inspector of schools within bracket AC shall disclose the medical report if obtained from the concerned chief medical officer of health. Stop. Affidavit in reply thereto, if any, be filed by 1 week, by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next paragraph. The learned advocate for the petitioner is directed to communicate this order to the non-appearing respondents by 10 days from date and file further affidavit of service on the next date.
Item number 18.
Yes.
18, I am appearing on the petitioner.
State.
Respondent number 5 I have served, but after from the affidavit, my lord, she received, so I could not annex the, my lord, SAC report.
Who is respondent number 5?
School authority. Actually,
State.
What is the matter about?
actually, date of birth, my lord, is my lord, educational credentials, admit card, registration number, certificate, my lord, mark sheet. My lord, I have annexed the birth certificate. Petitioner's date of birth.
Petitioner was a student of respondent number 5 school. My lord.
Or petitioner is an
Was the
employee of
student-
respondent number
No,
5
no, my
school.
lord. Was the student of respondent number 5 school. My lord.
Now petitioner wants correction of date of birth.
My lord, my lord.
Now
My-
petitioner is serving present. Where?
No, my lord. No, my lord. Not serving, my
Then
lord.
the school has to be heard.
Before that, kindly take page 10 for once.
You are representing
State. His grievance is that DI is not putting the counter signature. That is his grievance. So I am for the state. Kindly come to page 10 for once. At the very bottom. What? At the bottom of it, my lord, kindly see the remarks. No clerical error. Birth certificate was not produced at the time of admission. Now kindly take page 13 also. So there is no error, nothing. It is on his part. Page 13, kindly take page 13. That is the admission register.
Fourteen.
1-3.
Yes.
Against serial number 82, Devobroto Mondol. And kindly see the mark portion, round mark, 1/1/1987. And
So DI has obtained these documents from the school.
no, it has been annexed with this writ petition. From this, I can find.
No, but this document has been issued by the
school. This is a school's document. From this itself, it can be said.
It is there that
And he passed Madhyamik in 2003. Today, after so many years, he is coming to after 20 years for correction.
But it is the duty of the board to take decision on an application if made for correction of date of birth.
Yes, Lordship.
There is a provision to the extent.
It has not been submitted
Submitted.
before. It has not yet been
You make an
submitted
application before the board.
No, no,
I
this is the form with this.
This-
My lord, I have
Not-
obtained the
apologies.
form.
There is a particular form which has to be submitted before the board. This is the form which he has annexed, but it has not been submitted.
So why you have not
My
submitted?
lord, page 12, my lord, it has to be countersigned by the DI. my lord.
DI.
So DI has not
No,
countersigned.
That is the
because
my
of
lord,
this,
only
kindly see how the DI would take a decision.
Produced. Where from DI has got this? That the birth certificate was not produced.
It is not our document. The school has
No, no,
produced.
DI has made endorsement.
No. School's endorsement.
This is
The school itself is saying.
Explain.
Yes.
Mistake occurred.
Kindly see page 10.
DI has refused to countersign.
There is no
based on the
refusal.
endorsement made by the school.
School. As no refusal is there, but this, my lord, apparently the school is admitting that it is no clerical error. Kindly see page 10
And
serial
this
number 4.
document was annexed to this application,
Yes.
which was in the prescribed pro forma.
Pro forma.
Now, this document was obtained from the school authority by the petitioner.
Yes.
No, no.
Ah.
Yes,
I have-
this
Yes,
document,
yes, yes.
page 13.
My lord, kindly say.
Page 13.
Yes. Now kindly take page 10 serial
1st
number 4.
January 1967.
Yes, my lord.
So according to you, what is the appropriate date
My
of
lord,
birth?
page 18, my birth certificate, my lord. Page 18, my lord.
And the school says this.
21st of-
Page 18.
Yes, my lord.
And school
Xerox copy of my birth certificate.
and school says that no.
Just
Yes. Yes.
My lord, 21/8.
Your date of birth according to the school record is 1st January 1967.
1987.
1987.
1987.
My lord.
Just a minute.
বলো বলো বলো।
The school has to be heard.
Well, kindly take page 10.
Based on because the grievances against the school. DI has
No, my lord.
refused to put signature, but why the school has not on what are
No,
there in the
school
records
has,
of the school?
school has stated well, only one thing.
This
School
is-
has stated one thing that this document was not produced to the school. This birth certificate.
That I have seen.
Yes.
My lord, may I submit one thing, my lord? My lord, there is mismatch between the credentials and the birth certificate, my lord. Now, I obtained the actual, my lord, the application form by depositing 1,000 rupees, my lord. My lord, I have filled up the form. The school countersigned, my lord. Now, as per my lord,
The school
document-
DI has not countersigned.
DI is not, my lord, it's
Countersigned.
countersigned the documents, my lord. I have made the
If the
representation.
document is not countersigned by
How
the
could
DI,
I
how is it
submit,
difficult?
my lord?
It's the rules, your lordship.
That is
It has
the
to be done by the school and the DI, my lord. That is,
But
with
For submitting.
So
the-
if DI refuses to countersign it,
It is
because the
not-
decision is not to be taken by the DI.
But
Decision will be why DI has not countersigned it.
because
DI to countersign, he will
if your
submit
lordship directs, I will do it with this. Just a minute, because
Virtually, it appears that DI has taken decision.
no, DI has not taken any decision. It is the school.
No clerical error, birth certificate. That,
Kindly,
is to be, that is to be declared by the board.
No,
it is act a minute. No, kindly see serial number 4.
To explain how the mistake
Occurred. It is for the school. School itself is accepting that this birth certificate was never shown to the school. And the admission register also.
Situation, let it be submitted before the board. Then board
Very
will
well.
take a decision. Let the DI countersign. Let
But the moment DI countersigns, it is he. That means he has checked all the documents and giving his signature.
DI to check.
Very well.
Decision is to be taken by the board.
Very well, Madam. Kindly direct
Let the board takes and board is having the authority to call for the for
Absolutely.
school authority.
Very well.
Call upon the school authority to consider.
Kindly
this.
direct the DI to.
So let me direct the board that before taking decision, call upon the school authority and take a decision.
Yes. That can be done.
And
Can be disposed
I am
of,
ready
can
and willing to submit the original form, my lord.
Original certificate is taken. When the school was served,
My lord, I have served, my lord, I have.
show me when the school was served.
My lord, on 30.
হ্যাঁ যা করবে হ্যাঁ আমাদের কিছু তো নেই করে দিবি DI হ্যাঁ জমা করে ডিসাইড করে দিই অসুবিধা নেই লেট ইট বি ডিসাইড ডিসিশন নেয়নি তো রিজেক্ট করেনি তো
6th February, affidavit service filed on behalf of the petitioner is taken on record in spite of service of notice upon the authority of Ismail Chowk MYSB, full stop this up, Vidyalaya, Purbo Medinipur. Said school is not represented today. Stop. Next paragraph. The grievance of the petitioner is wrong recording of date of birth in the records maintained by the aforesaid school authority in connection in the records maintained by the aforesaid school authority. Since petitioner was a student of the aforesaid school. ওটা না said school করে দেবে। Hereinafter referred to as said school. Said school. Petitioner prays for correction of date of birth based on birth certificate dated 27 December 1989, wherein date of birth of the petitioner is recorded as 21st August 1988, whereas in the records maintained by the said school authority, date of birth of the petitioner was 1st January 1987. Stop. Next, stop. Petitioner made an application for correction of date of birth in the prescribed pro forma, which is required to be countersigned by the District Inspector of Schools, AC Purbo Medinipur, for taking decision by the concerned authority of the West Bengal Board of Secondary Education. Such application of the petitioner seeking correction of date of birth is at pages 10 to 11 of this writ petition. Next paragraph. Learned advocate representing the board submits, unless application in the prescribed pro forma is countersigned by the concerned District Inspector of Schools, board cannot take decision.
And submit it before the.
Stop. Learned advocate representing the state respondent submits, due to certain endorsement, due to an endorsement made by the school authority, by the said school authority on the application of the petitioner seeking correction of date of birth. Said application has not been countersigned. Next paragraph. This court finds that in terms of the procedure, concerned authority of the board is required to take decision on the application made by the petitioner seeking correction of date of birth. Stop. It is not the district inspector of schools to take decision. Due to failure on the part of the concerned district inspector of schools within bracket AC to countersign the application form, the petitioner could not submit same before the board for taking decision. Next paragraph. The district inspector of schools AC Purbo Medinipur is directed, being respondent number 4, is directed to countersign the application form of the petitioner by 7 days from the date of communication of this orders. Stop. After the application form is countersigned by the respondent number 4, the petitioner shall submit the same within 7 days thereafter before the concerned authority of the board. Stop. On receipt of such application, the board shall take decision on receipt of such application. Concerned authority of the board shall decide the same by 8 weeks thereafter. Next paragraph. Writ petition stands disposed of. Urgent xerox certificate.
Grateful, Lord.
May I have a lordship's time give to mention on matter for inclusion. For inclusion, under the hearing. Under hearing of which group? Group 6, your lordship. No, I am not including any hearing matters. No, this is some, it has some. No. Not kindly. Because I am hard pressed with motions. If I start including matters, then I will include. Sorry, yes. Please.
My lord, may I permit to mention one matter, my lord? This is a contempt application, my lord, for inclusion. Contempt application.
Contempt arising out of the order passed by this court.
Yes, my lord.
Yes, next Wednesday. Okay.
Very much of that.
Listed matter, original side, item number 1, prime link trade comp.
My lord, there's a subsisting interim order, my lord, restraining the corporation from taking any coercive steps. That, my lord, will find from 15 January 2025. May I hand up a copy of the order? Thereafter, it was extended subsequently on 22nd January 2025 for another month. My lord.
করবো আচ্ছা when initially interim order was granted?
My lord, 15 January 2025. There are two interim orders.
Interim order granted earlier is extended.
Yes. That, my lord, was an observation of Justice Roy, but my lord, that is not the interim order I'm seeking extension of. It is this 15 January. If my lord takes the last line, only that last line, the corporation is
So
restrained.
there
from
was no
taking-
previous interim order.
Previous, my lord, will kindly have a look. It is only for. There was a limited period of 3
So you
weeks.
want the order which was passed on
15 January.
15 January to be extended.
Extend.
I oppose that, my lord.
So let us live to fight another day, my lord. It's
It was later extended.
yes, 22nd January 2025. My lord will kindly have a look at this.
Yes. Yes.
For a period of 1 month that will expire on 22nd February 2025.
So previously it was extended.
Yes, my lord, may I humbly submit? My lord, I'll
Not
take.
a regular
No,
bench.
no, no,
Sorry. Yes.
no, the subsequent orders by the division bench, by the Honorable Chief Justice, which says this has to close down. This has not been told to your lordship, 14th of February, and this has not been mentioned. 14th of February, your lordship will kindly see the single bench order and the Honorable Division bench's order. This possibly cannot be extended, my lord, in my humble understanding. Subject to my lord testing it out. Kindly seize, my lord, same property. My lord, before this, may I indicate in a nutshell in a minute? I'm sorry.
Single bench order.
Two sentences of fact, my lord, if your lordship kindly permits, before this, if I take your lordship to the order. Both writ petitions concern the same premises, same business.
Not same party. That's
One is the matter which appears in my lord's list is a writ petition by the person who runs the business. The other orders which I have handed over.
But it is an order dated challenging 11th February 2020.
Yes. May I kindly gives me one minute. I'll narrate the entire facts in a minute.
And in connection with a different writ petition.
I'll tell you, lordship. Kindly gives me 1 minute. Two writ petitions are there. First is challenging unauthorized conversion.
Let me go through the order passed by the Honorable Division bench. Second page, last 4 lines of the first paragraph.
The appeal failed.
Yes. So the business has to close down. And they are saying
Preferred by whom?
preferred by them. The petitioner's appeal. But would your lordship kindly give me a minute, my lord? May I indicate, my lord, in a nutshell? 2 complaints made by 2
there
writ
is an
petitioners.
observation that we find there is no error in the exercise of discretion by the learned single.
Exactly. Lalit Singhal just says business has to close down.
But learned single judge at the same time extended the interim.
No, that is not. That's a different writ petition. May I kindly permits me?
So very well, you renew your prayer before the regular bench.
But-
Since it is in connection
in
with
a-
different- different-
But in a kindly gives me a minute, my lord. My lord, kindly gives me a minute.
So it's not a regular bench.
But this business has to be closed down, my lord. This is the finding.
Come up for extension of interim order, which was passed on 15th January 2026. Stop. However, Mr. Gupta, learned advocate representing
Respond number 18.
Respondent number 18 in the present writ petition has opposed extension of interim order. The strength of the order passed by the Honorable Division Bench on 14th February 2025. Stop. On perusal of the order of the Honorable Division Bench dated 14th February 2025, it appears that the Honorable Division Bench passed such order in connection with a different writ petition being WPO 1109 of 2024.
Same business, my lord.
Stop. Next paragraph. Hence, the interim order passed on 15th January 2025 stands extended. Till 5th March 2025 or until further order. Stop. List the matter before the regular bench on 26th February 2025, subject to convenience of the bench.
5th March or until further orders, whichever is.
early. Subject to convenience.
Hmm.
Subject to convenience. For a period of 2 weeks, you fight out your case before the regular.
Only thing was same business where the division bench said stop.
Issue is same.
One is the KMC conversion, other is fire license not being there. And fire license being a condition precedent.
It is in connection with separate writ petition.
But the same premises.
Yes.
Yes.
Next.
Item number 2, small 2.
Lordship.
Yes.
I have served this, your lordship.
Upon?
Upon the, on the register and the learned special.
Yes, but what about the determination of the sale price as directed by this court?
I have been informed that they want to, 8.70 is the amount, exact amount. Is due 8.70 crore. It's the
Whether you have you have got another person who is intending to purchase.
Yes, your lordship. I have heard that some.
You have heard that.
Yeah, I've got instruction, your lordship, that two other persons are now showing their interest to purchase the property.
There is no development from 15th February 2025. Is it the whether the court will wait till the purchaser comes up to and express intention to purchase the land in question? How long?
Lordship, I'm afraid, but I think your lordship
Then
has to wait.
the matter has to be heard on merit.
Lordship, there is as such there is no such merit because your lordship, as per the honorable division bench.
Now you tell me, if anybody is not, if any buyer is not found, any buyer is not found, then what is to be done? How long this matter is to be kept pending? Suppose for a period of 2 years no buyer is found, then what would be the other option left? Tell me.
I understand, your lordship, but as per the honorable division bench of this honorable court's order, your lordship, as a particular issue, particular issue has been framed, your lordship. In order to,
what is that issue?
In order to sell the property, your lordship.
Yes.
In order to sell the property, and after.
But if no buyer is found after such a long deliberation, then what would be the effect? You are appearing for the petitioner.
Yes, your lordship.
What would be the effect?
Afraid, your lordship, but I not able to answer your lordship's query because your lordship, I don't have any answer.
What is the issue involved in this writ petition?
Your lordship, mainly dues are payable by the company.
Upon purchasing by utilizing sale price.
Yes, your lordship.
Now, if no purchaser is found, what is the prayer made in this writ petition? Thou. Writ petition of 1998. How long it will be kept pending? Just 1 year after my enrollment. Yes. How long it will be kept pending?
And what had happened was the appellate board of the big companies had also dismissed it and directed winding it. It was challenged over here.
Use microphone, Mr. Dastu.
It was challenged over here with the idea that they had certain properties. A scheme was framed by all. The court had done it. When one property was sold and we met a lot of the dues. The special officers were asked. Now some dues were still there.
What was the order of BIFR?
Wind up.
Wind up. That was challenged in this.
No, AIFI also passed that. So that came over here on humanitarian grounds. The workers and all were there. So, my lord, keeping that in mind, the court interfered, made out a scheme, the property was sold and the monies were dispersed. Some amounts remained outstanding. Now, to meet those demands, we had to sell the other property. Because otherwise, my lord, all the government agencies, it's only government agencies' monies that are there. Provident Fund, ESI, banks, those. So the idea was just to try and get it off so everyone is, at least their claims are settled. That was all that there was left in this writ petition.
But how long court will wait?
My lord,
if right is not found.
Your lordship is right, but my lord, the thing is that your lordships.
Now, if the effect of AIFR is given, then what would be the result?
Well, the company which is otherwise now started functioning at a different.
That would
be wound up. Those workers will be let go, and my lord, government will be scrambling for their dues. The only thing is that we are hoping that we can at least sell the land so we can meet off all the dues.
Possibly, your lordship can be adjourn this matter for 2 months, and then after your lordship can dispose of this G application upon which this sale proceeding or sale is going on. This GA of 2019. Now Niramgana GA 11 of 2019, your lordship.
GA টা দাও তো।
Earlier order number is 1727.
Where there, which prayer you have made?
There, I have made the prayer that the disposal of these companies then at Krishnanagar in one or more plots at the best available price under the supervision of the joint special officers.
What steps you will take to find out a prospective buyer?
Your lordship would permit, then further we have we can make a paper publication. Sorry, joint special officer will make a paper publication.
And another Nozrul Islam will come. Isho.
My lord, may I just humbly suggest, instead of 2 months, gives it 3 months, with liberty to either the petitioners or the special officers to mention prior to that date if purchasers have been found.
Then indefinitely, Mr. Dastur, this matter will be kept pending.
No, lordship keeps it for 3 months hence. But I'm saying if before that we can find, say, 1 or 2 purchasers, then we will mention before your lordship and it can be preponed.
Application being GA 11 of 2019 are taken up for consideration in presence of the learned advocates representing the petitioners and joint special officers. Stop. Next paragraph. Learned advocate for the petitioners prays for further time to find out buyer of the plot of land at Krishnanagar, Nodia. Against best available price. In order to liquidate the area dues and also meeting the running expenses of the company, of the petitioner company. Stop. 8 weeks time is sought for to take further steps in order to find
out such prior. Stop. Next paragraph, Mr. Dastur Lana, senior advocate and one of the two joint special officers submits to submits for granting liberty or for granting leave to the learned advocate for the petitioners to bring it to the notice of the court when any person comes forward to purchase the land in question. Next paragraph. Hearing of this matter stands adjourned till thirtieth April 2024, when it will appear under the same heading. Stop. In the meantime, any before the next date, if petitioners find any buyer, or if petitioner finds any person or organization which is intending to purchase the plot in question, leave is granted to the petitioner to mention the matter for placing the same on board before 30th April 2024.
With notice.
With notice to the learned advocates representing the respondents as well as joint special officers.
I'm deeply obliged.
Item number 3, show Mr. Sengupta. Item 3.
I have released previously.
Please devote your own to
The writ petition stands released on personal ground and be placed before the Honorable Chief Justice for assignment. Yeah, for the school. I had the occasion to. Yes.
for the school.
Better option, otherwise it would have been converted. Yes. All the matters from the supplementary list motions.
Monthly. No, don't. No. Item number 66 from the left side.
Who is happening for the petitioners?
At the time of call, no one appears for the petitioners and no accommodation is prayed for. List the matter under the same heading. In the monthly combined list of March 2025. Nobody is there, what can be done? Nobody is there, matter has been called on 5 minutes back. Hold your breath. 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 Yes.
My lord, Pinaki Bhattacharya is appearing.
Inform him. Where is he?
Sir, he is on the code number 13. We can
Inform him that matter is being heard to come from code number 13. Now you are fit to place your matter. Yes. Yes. Yes, yes, yes. Place your case. Now, Ms. Das, please tell me that you have shown yesterday order dated 5th April 2023 passed by a coordinate bench which is part of your affidavit, supplementary affidavit. Now, that matter was confined to petitioner number 1. So for petitioner numbers 2 and 3, they are not covered by the order passed by the coordinate bench on 5th April 2023. Now, on perusal of this order dated 5th April 2023, it appears that at the time of superannuation of the petitioner, rupees 2,08,396 was found to be overdrawn, which petitioner on demand deposited, and thereafter pension case of the petitioner was finalized, settled, and petitioner number 1 received pension. After that, petitioner filed this WPA 4008 of 2023. Order was passed by the coordinate bench. I will come on the observations made by the coordinate bench in this order later. Now, you tell me that why this amount was found to be overdrawn. Take your seat. Why this amount was found to be overdrawn?
Can you see this one? Page number 20.
Okay, read petition. Just a minute. Yes.
Here is the sanction. In that basis, you cannot exempt. But at the time of impairment, Petition Department notice that the capital was impaired. That's why it directed to refund.
So the refund was the calculation of refund was due to payment of 3% additional increment.
Without capital.
It was according to it was sanctioned with a memo dated 8 April 2015. But at the time of calculation of your retirement dues, while processing your pension case, it was found that without any approval, this was sanctioned.
That's why.
So it was found to be overdrawn.
But it has not been decided that I am not entitled.
Now it was, yes, it was found to be overdrawn.
Yes.
Now you paid that amount.
Because we have already, what it was
The
already.
fact remains you paid that amount, you refunded that amount and obtained pension. Then you filed the writ petition being WPA 4008 of 2023. Refund. Now there the honorable the coordinate bench allowed the writ petition, directed the authorities to refund the amount. Amount was refunded. Now what more you are required to get?
On letter, Commissioner was not responsible for fixing of such erroneous mistake. So my humble prayer, it was option. It does not mean that it's a circular that I am not
Where code? Yes, where the code directed. Observe.
That one put down at the
No, yes, but
earlier.
in the writ petition, in the present writ petition, you are praying for sanction of 3% additional increment. So far, petitioner number 1 is concerned. Now we are restricted the issue. You are restricting the issue to petitioner number 1 only at present. Now this 3% additional increment, which was found to be released in your favor without any approval, was found to be overdrawn and which was refunded by you, and subsequently by the dint of order dated 5th April 2023, it was paid back to you. So if this 3% additional increment in the form of refund was subsequently paid back to you, so then what remains?
But my claim was out because that's circular.
What claim?
That is 3% additional interest.
That has already been paid to you in the form of refund.
That's why what my understanding, whatever the calculation or that usually it is not the running model.
We need at this stage we need not enter into this issue. Please think about it twice. That suppose 100 rupees was found to be paid in excess, rightly or wrongly, calculated by the authority while determining your pension case. You refunded rupees 100. Then pension case was settled. After settlement of pension case, you filed a writ petition for refund of 100 rupees to you. Now, this calculation of excess payment might be for granting an incremental benefits. Is 3% additional increment? It is 3% additional increment. Suppose in the form of 3%, suppose due to sanction of 3% additional increment, if department finds rupees 2,08,396, but there the component of 3% additional increment is there. But you have received this benefit during your tenure. You have received this benefit. You lost this benefit since you had to refund it. Then you again received this benefit, but on the strength of the order dated 5th April 2023. So if ultimately you have received this benefit on the strength of the order dated 5th April 2023, what more department is required to pay? After what you are entitled? When? Because it has already been paid to you till the date of your retirement.
Additional increment.
No, that is a part of your salary component. That is a part of your salary. No, because that is an incremental benefit. Pension is fixed based on your basic pay. 50% of the basic pay plus dearness allowance. Yes, no. So ultimately you have received this benefit because the refund was due to excess payment of 3%. that is according to you wrong calculation. Then rupees 2 lakh, then rupees 2, just a minute, then rupees 2 lakhs 8,396 was refunded by you. Then you filed a writ petition. No, look here, this is a wrong step taken. But the premise or consideration of the court was different. Court proceeded on the in terms of the ratio laid down in Rafiq Mashi, that once it is paid rightly or wrongly, this cannot be taken back. But in effect, you have received the benefit on the strength of the order passed by the coordinate bench on 5th April 2023.
My understanding that is
Yes. So what if today, if this court directs the state respondents to grant 3% additional increment, that will be double payment. After retirement, this 3% additional increment does not arise because your pension is fixed based on your basic pension and dearness allowance. And to that extent, you have not made any prayer in the writ petition for refixation or consolidation of your pension. You have, let us come to the prayer made couched in this writ petition. Respondent authority to grant 3% additional increment in favor of the petitioner. That you have already received. You have received it. Yes. No, it's an incremental benefits. So let me dispose of the writ petition, granting you leave to take file writ petition afresh. So far, petitioner number 2 and 3 are concerned. Not 1. 1 I will not pardon. I'll reject this writ petition. Issue. Yes. That issue will be kept open.
May I leave?
No. No, in one matter, in case of petitioner, I will dismiss. In case of petitioner 2 and 3, I will allow. That is not that is not the proper order. That will be a wrong order.
May I leave my?
Yes.
May I leave?
Yes.
No.
When you have retired, Ms. Das, when your client petitioner number 1 retired. 22.
I have already got the
By way of refund. That was the excess drawn amount calculated. By instituting this writ petition, 3 headmasters of 3 different higher secondary schools, 3 different higher secondary schools have approached this court claiming 3% additional incremental benefits for manning the post of headmaster in their respective schools. Stop. After hearing the learned advocates representing the petitioner and state respondents, it appears the facts facts relating to case made out by petitioner number 1 is completely different from the facts completely different from the issue involved in connection with the case made out by two other petitioners, being petitioner numbers 2 and 3. Next paragraph. Therefore, the issue relating to service of the petitioner number 1, where sanction of 3% additional incremental benefit in his favor is taken into consideration. Stop. Petitioner number, next paragraph. Petitioner number 1 retired on superannuation on 30th November 2022. But 30th November 2022 and till date of his superannuation, petitioner number 1 has drawn 3% additional incremental benefits for manning the post of headmaster in higher secondary school. Stop. Stop. However, while processing the pension case, state authorities found without according necessary approval, such 3% additional incremental benefits were enjoyed by the petitioner till the date of his superannuation, requiring refixation of pay of the petitioner number 1. Stop. On refixation of pay of petitioner number 1, rupees 208,396 was found to be payable. Now, was found to be drawn in excess by the petitioner, which is connected to yes, who is shouting there? Which is connected to sanction of 3% additional increment. Stop. Petitioner on demand refunded rupees 208,396. Thereafter, pension case of the petitioner was settled, and on issuance of pension payment order, retirement dues including pension were released in favor of the petitioner. In favor of the petitioner number 1. Subject petition number 1 korbe. Petitioner number 1. Stop. Next paragraph. Subsequently, petitioner filed a writ petition being WPA 4008 of 2023, claiming refund of claiming payment of amount, payment of sum which petitioner number 1 had to refund to meet the demand of the state authorities based on calculation of excess amount drawn by the petitioner. Stop. State writ petition was disposed of by a coordinate bench
video order dated 5th April 2023 with an observation as follows. এই যে এইখানটা সেট আউট করুন। স্টপ। Ultimately, the coordinate bench directed the concerned state authorities to release sum of rupees 208,396 along with 8% interest per annum within a specified time. Next paragraph. In terms of the order dated 5th April 2023, sum of rupees 208,396 and accrued interest thereon was paid to the petitioner. Next paragraph. In view of payment made by the state authorities in terms of order dated 5th April 2023, it appears that the benefit of 3% additional increment, which was found to be wrongly paid to the petitioner by the state authorities while processing the pension case of the petitioner, was ultimately paid to the petitioner in a different manner. Stop. Since sum of rupees 208,396 along with interest is paid, claim of the petitioner towards 3% additional increment for manning the post of headmaster in higher secondary school stands redressed. Stop. Therefore, no order need be passed on this writ petition for further payment in consideration of claim of the petitioner towards 3% additional incremental benefits. Stop. Hence, the writ petition in connection with petitioner number 1 stands dismissed.
Regarding fixation of the
Stop. Next paragraph. Petitioner, however, the issue relating to sanction of 3% additional incremental benefits as claimed by petitioner numbers 2 and 3 is completely different, which ought not to be gone into in the present writ petition. Stop. Leave is granted to petitioner numbers 2 and 3 to file to take steps in accordance with law, including filing of writ petition afresh on self-same cause of action.
So I give only one maximum. Originally, again, two petition I have to file.
Stop. Next paragraph, urgent Xerox certificate.
You take decision whether what you will do. Court will not grant any.
May I start on the my way that regarding the condition of the patient, treatment cannot be adjusted.
Increment can be adjusted or cannot be adjusted. That chapter is closed by virtue of the order of Justice Biswajit Basu. Rightly or wrongly, it has been paid. You have not preferred appeal against that order, but you have got the benefit in a different manner, as I have recorded in my order.
Benefit I have got, but the fixation has not been properly done.
What can be done?
Okay. But when it's again true, I have come whether again.
That I cannot tell anything now. Yes. Matters from monthly list.
Item number 118 from monthly list of appellate side.
Milord, we beg to appear on the state respondents, and Milord, we have been directed to file a report. This is the report, Milord. Your Lordship kindly goes to the previous order. Milord, report a copy আছে?
This is my affidavit of service pursuant to my lord's.
By which order report was directed to be filed?
Milord, on 1st November 2023, Justice Gangopadhyay, Milord.
Yes, what is the present position? Now you have resumed your duty.
But at the moment the police protection was given to me, but I went to the school. But after 1 month, the same situation happened, and the police was there. In front of the police, but I was heckled inside my school. Let the headmaster room was ransacked.
You are the headmaster of the school?
Yes. Let my scooty was broken. Let threat has been given. But I was kept there inside the school, and with the protection of the SDPO, that I was rescued, and I gave verbal undertaking before the local people that I will not come to the school. It's a life threat.
What is the stand taken in this report?
But kindly see the report once. But that's why
By the DI?
But
What is the stand?
But only one thing. But I filed a second writ petition that is appearing as item number WPA 49. But it's item number. Give me 1 second. Very close to this matter. It is item number 186 on this point. That when the police protection was given to me, I went to the school. That I was beaten up inside the school. Now, it's a position that I cannot go to the school.
So why you are being prevented?
Milord, what Lati allegation, Milord, that has been.
The allegation is that a student of class 8 expired because of dengue. The class was suspended. I being the headmaster, I told that after 4th period at the midday meal was prepared, you take the midday meal and then we will go to the house of that student. But the teachers, they provoke the students to quit the class and go to the house. This has resulted the entire incident. And
the Rati incident.
And this is the next.
What was the Rati incident? But the allegation is very,
May I?
that he is having an affair with a lady teacher. That's the students and teachers and local people, they do not want this.
If somebody is making allegation against me, has it been proved yet? Nothing.
But if you
No case has been registered. Nothing.
Will you file an exception to this?
Not sure.
But there is a direction of the board, Milord, to make an inquiry. There is also a
186 of the combined list.
Yes, yes. But I request your lordship that both the matters can be taken up together because of the.
Sir, no board is a fund.
Here, board has not only.
In terms of the order, dated
বোর্ডের আছে
বোর্ডে কোনো ফাংশন
ইনকোয়ারি ডিরেকশন দিয়েছে
a report in the form of affidavit
এই থাক না
অনেক আগে
affirmed by
দিয়েছে অনেক আগে
AC North 24 Parganas. Barashat. Not to AC Barashat, not 24 Parganas. Report in the form of affidavit affirmed on 22nd November 2023 is filed today and same is taken on record. Client advocate representing the petitioner has prayed for opportunity to file an exception to this report. Let an affidavit taking exception to this report be filed by fortnight from date. Next paragraph, list the matter under the same heading in the monthly combined list of March 2025, along with a writ petition being
just a second.
186.
Give me 1 second.
এই দেখো তো 186 combined list. Oh,
yes, 186.
Along with the writ petition being
WPA 49.
Just a minute. Being WPA 49 of 2024 within bracket Anupam Sardar versus State of West Bengal and others, which is appearing at serial number 186 in the monthly combined list of February 186 এর সঙ্গে অ্যাড করে দেবে।
In the next matter, I am not for the state, in the next matter, item number 1.
It will be taken up when lordship. You are appearing in one matter. If nobody appears, then I will direct you to take
lordship.
Great.
No proceedings, nothing.
Nothing.
Board director has to make an
Why
inquiry.
you are not taking steps for transferring the petitioner to some other state?
That is not fair.
No form.
Second petition.
That is in the second petition.
Yes, transfer the petitioner to
I have to take
Harabe school.
I have to take the instruction.
I sought for. I cannot go to
Matter can be
that lady teacher,
from
the
issue can be resolved.
from my report, it would be evident that lady teacher sought for sought for transfer.
One of the two teachers,
Yes.
since the petitioner is the headmaster of the school, transfer him to some other school as headmaster.
Yes.
That will be the only solution.
Yes.
Since there is no suspension, there is no disciplinary proceedings, transfer the petitioner to some other school and the issue can be resolved.
Since he should find lordship.
Add a line. Commissioner is a party.
Commissioner, yes. Commissioner is a party.
Considering the allegation made against the petitioner, Commissioner of School Education West Bengal, which respondent in the present petition?
Commissioner 2.
Commissioner of School Education West Bengal being respondent number 2 is directed to explore the possibility of transferring the petitioner to some other school as headmaster. Now, the steps taken by the steps to be taken by the Commissioner of School Education before the next date of hearing shall be disclosed by filing a further report by the Commissioner.
So report, only report, simple report or report in the
Simple report.
lordship.
Take decision, transfer him.
Lordship.
Great.
Then he will be relieved and the problem will be resolved.
Yes.
হবে না পরেরটা?
সোয়া 3টে অব্দি তো, কালকে হবে। হবে না, কালকে হবে। ওনার থেকে দিয়ে দে, কালকে একদম কবে
পরেরটাই তুমি আছো নাকি?